You want these, Steve? You want these? Jamie, can you give me this stuff?
All right. You all ready? All right, good morning, everyone. I'm Judge Blake Adams. We're here for criminal jury trials this morning. We have one case on the docket, Jarrett Berg Smith, case number 20 CT 777 with Ms. Armpriester. Good morning.
Good morning.
Okay. State ready?
State's ready, Your Honor, if I may.
Yes.
The state informed Ms. Armpriester earlier this week that our civilian witness who's coming from Tampa, he will be here today. His company has a no drop policy. He is scheduled to drive tomorrow. He is a truck driver. Our hope is that we can get this entire trial done in one day. If we are unable to, the state would request that Ms. Armpriester be allowed, if she chooses to call him and her case in chief, to do so ahead of our general procedure, to allow convenience for him and to allow Ms. Armpriester to be able to direct it.
We've already discussed this, that's fine.
All right, very well. Since you're both in agreement, we'll see how we go today.
I certainly don't want to delay any responsibility to keep in track.
All right. All right, I've already been informed that the docket has been removed from outside of the courtroom. We discussed the number of witnesses yesterday. I believe the state said they had 3. All right. And Ms. Armpriester, do you know how many you'll have today? Or, okay. And we have 2 videos?
Yes, Your Honor.
And 1 day?
Yes, Your Honor, the videos have been redacted to about 20 minutes apiece.
Okay.
They are not long videos.
All right. I'm going to tell the jurors the estimated length of the trial is 2 days, just so that if we go 2 days, we didn't tell them something different. All right. Any foreign language interpreter needs from either side?
No, Your Honor. And then, when we step outside, just go to the speaker.
All right. Good morning, Mr. Smith.
Good morning.
Have all plea offers been communicated to the defendant?
They have, Your Honor. The court would like,
Well, have they been, are they still available?
I believe the state can wait to be first by minimums, and Mr. Smith having rejected that offer.
All right. Mr. Smith, will you raise your right hand to be sworn by the clerk?
Please don't swear on honor that this testimony you shall give shall be the truth, the whole truth, and nothing but the truth.
Yes.
Will you state your name?
Derek Smith.
Mr. Smith, did Ms. Armpriester relay the plea offer to you? Okay. Do you need any an opportunity to speak with her about that before we proceed to trial?
Do you want to talk about the plea? We can.
I mean, no, because that's the reason why.
All right. So is that a no?
Yes, sir.
Okay. All right. And you understand that is this a DUI first
Yes, Your Honor.
under .15?
Yes, Your Honor.
You understand the maximum sentence in this case is 6 months in the county jail?
Yes, sir.
Okay. And at this time, you're rejecting the plea offer?
Yes, sir.
All right. Thank you, Mr. Smith. And the Do you have a copy of the information for the court?
Yes, Your Honor, and this has been shared with Ms. Humphries as well. The black redactions reference to the controlled substance.
Okay. And Ms. Armpriester, when I read the information, I presume you want me to leave off misdemeanor?
Yes, Your Honor. Sorry, I saw that part of the file.
And it leaves off the breath as well.
Okay. And you're in agreement with the redactions to the information that the state has made?
Yes, Your Honor.
All right. And does Mr. Smith, are we using his full name, Jarrett Berg Smith?
Yes.
Okay. All right. Any issues with prior convictions with the defendant or any witnesses? Right. I see we have Mr. Persure here this morning. Good morning. And I'm sorry, Ms. Santini, good morning. I didn't say good morning to you. Will either side be invoking the rule? All right. And when are you invoking that? Okay. All right. If I don't see any witnesses in the courtroom, make sure that your witnesses know not to come into the courtroom and to remain outside, not to talk about the case until they're called in for questioning.
Yes, sir.
I received a copy of the jury instructions and verdict form. Ms. Armpriester, did you receive a copy?
I did, Judge Ryan.
Okay. All right. We'll review them at a later time.
Yes, sir.
Very good. Is either side requesting a special jury instruction?
Judge, we included already jury instruction, and at the time that we get finished, Mr. Smith testified, we would ask that 3.9A be removed. Other than that, I don't believe there's any other special instructions that are already in there as we did previously.
All the senators.
Okay. Very good. Ms. Armpriester, are there any stipulations or concessions as to any of the elements of the crime?
No,
Are there any technology needs that need to be addressed other than the TV?
Your Honor, for purposes of impeachment, I'm planning ahead, I may be playing portions of the media that we have, rather than excusing the jury each time. I'm trying to procure a set of headphones that it can just be played that way, unless the court would prefer to excuse the jury should that issue arise.
Mr. Rab?
Your Honor, I would request that the jury be removed if it is going to be played, the jury will be able to hear anything that would be prejudicial to the state's case in any way.
Well, that's why I say the headphones, then they wouldn't hear it anyway, it would just be.
And I'm not certain if it's a part that the state already intends to play, obviously we certainly wouldn't have an issue with that. It would likely already be in evidence. It is something that has previously been redacted. I would turn over to the court, to Ms. Armprister's request and our stipulation, and I think we can address it at that time.
I mean,
Impeachment.
why wouldn't the jury hear something for impeachment? Isn't that the whole purpose of impeachment, is to discredit the witness?
I think the concern Ms. Armprister's alluding to is that with the media capabilities, there may be something that is played that is not intended to be played at the time in front of the jury before that specific part for impeachment is published to the jury.
So the headphones would be for your purposes to get to the right spot?
No, Your Honor, some things that we agree the jury wouldn't hear that wouldn't come in substantively of evidence can still be used for impeachment purposes. We
Right, but
wouldn't want that.
if the jury doesn't hear what's being played for impeachment purposes, then why impeach them?
Because then the witness, my questioning of the witness would go into if they recall giving a different statement.
But how does the jury know that they're being impeached if they don't hear what they're being impeached of?
My understanding is that the purpose of the headphones is to make sure that the right portion is played.
All right, well, let's address it when we get there, if we get there. All right, does either side have any objection to allowing the jurors to take notes? One alternate?
If we're gonna do a 2-day trial, last time Mr. Rapp and I agreed to 2 alternates only because of an issue of people not coming back the next day. But that was over a weekend, so perhaps with 1 day, we might be okay with 1.
And Your Honor, I would also suggest to perhaps if we need a second panel for a single alternate, maybe we have that discussion at that time.
All right,
I'll defer to the court if having 1 or 2. Mr. Rapp and I have done 2 before.
all right. We did one last time, didn't we? All right, we'll come back to that. Any objection to the court reading portions of the standard jury instructions as it relates to reasonable doubt and the defendant's constitutional right to remain silent prior to voir dire?
No, Your Honor.
No.
I hope the answer to this question is no. Are there any preliminary motions that need to be addressed?
No.
All right, I think we've probably covered all of them. Any additional preliminary matters to review?
Not on.
Have the parties been provided copies of the juror packets?
Yes.
I don't think I've been provided a copy.
Oh, no, I'm sorry. Just
Could we get the packets down, Natalia?
We have not. Do you want me to request?
Yes, please. How much time do you need to review the packets before calling down the jurors?
15 minutes.
Ms. Armpriest? All right. What is the estimated time each side will need for voir dire? How long?
maybe 30 minutes. Maybe 30 minutes.
All right, I'll give each side 30 minutes. Obviously, if you need more time than that, you can request it. Do you want a 5-minute mark or 10-minute?
5 minutes, I believe. That's fine.
All right, and so Ms. Santini, you'll be conducting voir dire?
Yes, sir.
And Ms. Armpriester?
Yes, sir.
All right.
Your Honor, is there any objection to all 3 of us being at the same table? We did that at my last trial, or must we be separate?
I'll leave that up to the 3 of you.
Thank you. That's the part I was.
All right, and Natalia, will you make sure that the panel that's brought down has been sworn?
Okay, there we go.
All right. All right. Anything else?
There you go.
Okay. All right, then we're waiting for the packet, and then why don't we be in recess until 9:35? Okay? Thank you. All right, we're back with State of Florida v. Jarrett Berg Smith, case number 20 CT 777. All parties, including the defendant, are present. Are we ready for the panel? Kate, ready? I'll give you 3 minutes. Because I've got them lined up waiting. Right. All right, could we have the panel brought in?
Your Honor, the jury pool.
Thank you. All right, thank you. You may be seated. Good morning. I'm Judge Blake Adams. Welcome to your Collier County Courthouse. I want to thank you for fulfilling your civic duty, but I especially want to thank you for being here at this time during the current COVID pandemic. Jury service is especially challenging during the pandemic. The Chief Justice of the Florida Supreme Court recognized early on that while you can choose to go to the grocery store or restaurants, for the most part, you have to come to court. As such, it is important for us to make it as easy and safe as possible while you are with us. Is anyone having any difficulty hearing me? I see no one shaking their head yes or saying yes. Okay, very good. Like law enforcement, EMS, or the fire department, the court never closes. This is true even during the pandemic. We have adapted many new procedures over the course of the past year in order to keep the courthouse open. It is extremely important for the judicial system to remain open even during the pandemic, because we are dealing with various fundamental rights guaranteed under the constitutions of both the United States of America and the state of Florida. Among these are the right to be advised and understand the charges being brought by the state, the right to confront one's accusers, and the right to a trial by a jury of one's peers, the right to fundamental due process of law when one is facing the loss of life, liberty, or property. It is important for the judicial system to stay open, and it is vitally important for you, the citizens of Collier County, to answer your call to jury service so we can ensure that justice is served and everyone's rights are properly protected. Those of you who have previously served on a jury are going to see that some of the things will operate a little differently. Everyone will have masks on while we're in the courtroom. We will practice social distancing as best we can. We have hand sanitizer inside and outside of the courtroom. And I'm sure you all understand why we're taking these precautions. We ask that all of you wear your masks while you're in the courtroom. We ask that you maintain social distancing from each other while standing, walking, or sitting in the courtroom, and all of us will try doing the same during the trial and during breaks. Also, we ask that if you don't feel well during the day, please let one of the bailiffs know. Additionally, if you have to come back tomorrow and you don't feel well in the morning, please call the clerk's office, let them know, and don't come back to the courthouse if you're not feeling well. In an effort to reduce the number of people in the courthouse at any given time, we have not been allowing the public access to the courtrooms. Instead, you will notice that we have several cameras around the courtroom, including the one mounted on the tripod. These cameras allow us to live stream these proceedings on YouTube via Zoom, so any interested members of the public can observe the proceedings from the comfort of their homes or offices. Just like any media camera that occasionally sets up in the courthouse, the cameras are specifically positioned so as not to put any of the prospective jurors' faces in the shot. After the jury selection process, the cameras may be relocated, but it will always be positioned so that members of the jury are not in the camera angle to protect your privacy as much as possible. During the trial, you are also going to notice that the attorneys will be using hand sanitizer. They may be wiping down the podiums. The witness box will be wiped down. These are all precautions that we're taking due to COVID-19. In addition, the courtroom will be sanitized nightly. And unfortunately, this means that transitions may take a little bit longer and the trial will proceed a little bit more slowly than normally. We appreciate your patience as we work through these safety protocols. We are working very hard to help you feel safe while you are with us and to keep you safe. If you notice anything or feel uncomfortable about anything, please let one of the bailiffs know. I will ask for your feedback at the end of the process. As I mentioned, what you do here is critically important to all of us, but we also want to make sure that you feel as safe and secure as possible while you serve your community. Again, is there anyone having any difficulty hearing me? I see no hands or anyone saying yes. All right. I realize that serving on a jury panel is not always convenient. However, your service gives you an opportunity to be a part of the administration of justice by which the affairs and liberties of your fellow men and women are determined and protected. Juries are one of the things that separate us from other countries where people don't have the privilege of having juries determine their outcome of their cases. While I will make every effort to see that the demand upon your time for this call to jury duty will not be unreasonable or prolonged, every effort will be made to see that your time is not wasted. This is a criminal case, so before we get started, I want to give you some information on the nature of criminal trials so you'll have a better understanding of what to expect. If at any point you have any difficulty hearing or understanding me or one of the attorneys, simply raise your hand and I will call upon you. Does everyone understand? Okay. Please make sure to answer all questions out loud when called upon specifically, because these proceedings are being recorded electronically. And unfortunately, we only have a couple of microphones set up in the gallery. In order to have a fair and lawful trial, there are rules that all jurors must follow. A basic rule is that jurors must not communicate with anyone, including friends and family members, about this case, the people and places involved, or your jury service. You must not disclose your thoughts about this case or ask for advice on how to decide this case. I want to stress that this rule means that you must not use electronic devices or cell phones to communicate about this case, including tweeting, texting, blogging, emailing, posting information on a website or chat room, or any other means at all. Do not send or accept any messages to or from anyone about this case or your jury service. In addition, your cell phone, smartwatch, or any other electronic device must be turned completely off while you're in the courtroom. You must not do any research or look up any words, names, maps, or anything else that may have anything to do with this case. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. All of us are depending on you to follow these rules so that there will be a fair and lawful resolution to this case. Unlike questions that you may be allowed to ask in court, which will be answered in court and in the presence of the judge and the parties, if you investigate, research, or make inquiries on your own outside of the courtroom, the trial judge has no way to assure that the information you obtain is proper and relevant to the case. The parties likewise have no opportunity to dispute the accuracy of what you find or to provide rebuttal evidence to it. That is contrary to our judicial system, which assures every party the right to ask questions about and rebut the evidence being considered against it and to present argument with respect to that evidence. Non-court inquiries and investigations unfairly and improperly prevent the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions, such as serving time in jail, paying a fine, or both. If you become aware of any violation of these instructions or any other instruction I give in this case, you must tell me by giving a note to one of the bailiffs. The Florida Rules of Criminal Procedure and Rules of Evidence govern the conduct of a criminal trial. Some of the rules require jurors to adjust traditional notions of fairness, especially the natural tendency to want to hear both sides of a dispute. A criminal trial does not follow the familiar form of a high school debate. Evidentiary rules and constitutional considerations often preclude presentation of information which jurors may feel would be helpful in deciding issues at trial. One example of such a rule is so basic to our system that it is contained in our Constitution itself. The Fifth Amendment provides that a person accused of a crime has the absolute right to remain silent and to require the state to prove its case without any assistance from the accused. When a defendant invokes this right, the jury is not permitted to be influenced in any way about that decision. The hearsay rule is another example of a rule of evidence that restricts information at trial. A statement made outside of court by a person and offered for the truth of the statement is generally considered to be hearsay and is usually inadmissible. There are many exceptions to the hearsay rule, and some of them may apply to the evidence in this trial. Presumptions have long been a part of criminal law. The presumption of innocence is an example. Our system of justice is accusatorial in nature. That means the state has the power to accuse and the burden to prove a charge against a defendant. As a result, a defendant is presumed innocent until proven guilty beyond a reasonable doubt. In just a moment, I will be going over the definition of those presumptions with you. The point of this explanation is to tell you that a jury in a criminal trial may only consider evidence which is admissible in court and not necessarily all of the evidence that might be available. While this procedure may not equate to your traditional notions of fairness, it is the result of many years of study, and it allows only the most reliable types of evidence to be considered by juries. The search for the truth deserves no less. The case we have for trial today is the state of Florida v. Jarrett Berg Smith. Is the state ready to proceed? Is the defense ready to proceed? All right, thank you. All right. Will the attorneys for the state please introduce yourselves?
Assistant State Attorney Lawrence Rabb on behalf of the state of Florida.
Thank you. Will the attorneys for the defense please introduce yourselves and your client?
My name is therein, and I represent Jarrett Berg Smith along with Mr. Mark.
Thank you. All right. Would the state please read its list of potential witnesses?
Mr. Eagles State Trooper Hernandez, and Warren County Sheriff Sergeant.
Thank you. Does the defense have any names to add to that list?
Yes, ma'am. Potentially, yes.
All right, thank you. Now let me ask this. Does anyone know any of the attorneys, the defendant, or recognize any names of the potential witnesses? All right. No one seems to know any of those. Does anyone know any of the bailiffs in the courtroom, the clerk, or myself? See people shaking their heads no. All right. The attorneys have advised me that this trial should be no more than 2 days. We will recess for lunch, and we will have at least one mid-morning and mid-afternoon break. With that in mind, is there any member of the jury panel who has a conflict that would prevent them from serving as a juror in this case? I see one hand. Ms. Asala, is that right? Can you tell me your name? Can you say that a little louder? Camden, okay.
Number 14, Your Honor.
Thank you. All right, my list is different. Okay. Ms. Bach? Okay, all right. Ms. Bach, what kind of conflict do you have tomorrow or today? Ms. Santini, would you like to inquire?
I see that you put that you talked to mother drive you, that would also need support. If needed, are you able to stay for today? I'm not sure. Okay, and what about for tomorrow? Yeah. Okay. And if we were to choose you as a juror, would you be able to focus on the case at hand if you have these concerns? Okay. Nothing further.
All right, Ms. Armpriester, would you like to inquire? All right, thank you. All right, thank you, Ms. Bach. Is there anyone else that has a conflict knowing our schedule? All right, I see no other hands. As I mentioned a moment ago, this is the state of Florida v. Jarrett Berg Smith. I will now read you the pertinent portion of the information which sets forth the charge against the defendant. The information is not to be considered as evidence, but as a mere formal charge against the defendant. You must not consider it as evidence of the defendant's guilt, and you must not be influenced by the fact that this information has been filed against the defendant. The information charges that the defendant unlawfully committed the following crime: driving under the influence, Florida Statute 316.193. In the name and by the authority of the state of Florida, Amira D. Fox, State Attorney of the 20th Judicial Circuit of the state of Florida, by and through the undersigned Assistant State Attorney prosecuting for the state of Florida, in the County of Collier, under oath, information makes that Jarrett Berg Smith, 1, on or about April 25th, 2020 in Collier County, Florida, did unlawfully drive or was in actual physical control of a vehicle within the state while under the influence of alcoholic beverages when affected to the extent that his normal faculties were impaired in violation of Florida Statute 316.193 against the peace and dignity of the state of Florida. I am now going to instruct you on a few basic rules of law. I will repeat these rules again at the end of the trial. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. This presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving 1, the crime with which the defendant was charged was committed, and 2, the defendant is the person who committed the crime. The defendant is not required to present evidence or to prove anything. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his or her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then that charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you will look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. At this time, the attorneys will ask you questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as voir dire, which is French, meaning to speak the truth. All of you have previously been sworn to truthfully answer all questions as prospective jurors in this case. A voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain a jury which will impartially, try the issues of this case based solely upon the evidence presented in this courtroom and on the instructions on the law given by the court to you without being influenced by any bias, prejudice, or other factors. Please understand that this questioning is not for the purpose of prying into your affairs for personal reasons, but is only for the purpose of obtaining an impartial jury. If your truthful answer to any particular question might be embarrassing or uncomfortable, you may simply raise your hand and request that we discuss your answer privately up here at the bench with the attorneys. From this group, we will select 7 of you to serve on this jury. Obviously, many of you will not be selected. If you are excused, please do not feel offended or feel that your honesty or integrity is being questioned, because it is not. Please do not infer anything or read anything into the questions the attorneys ask you. What the attorneys say now or at any other time during the trial is not to be accepted by you as evidence or law. In fact, they are not allowed to tell you what the law is. That job is for the court. However, the attorneys are permitted to ask you questions relating to your existing opinions or understanding of legal terms such as the presumption of innocence, the burden of proof beyond a reasonable doubt, or other legal doctrines. You need not be concerned about giving a wrong answer to these questions about the law. Just answer the questions as best you can. As a reminder, please answer all questions out loud as we are electronically recording these proceedings and need to ensure that a complete and accurate record is made here today. All right, again, is there anyone who's having any difficulty hearing or understanding me? All right, I see no hands. All right, Ms. Santini, you may proceed.
I wish you all could see my face so I could smile at you and hopefully give you a better, brighter morning since you have to be here in court today. But I do want to sincerely thank you all, because I'm sure you've already been told in your previous video and information that you had this morning that we are very thankful for you to be here. We couldn't do it without you, as truly as I can say that. And as I stated earlier, I am Nicole Santini, Assistant State Attorney for this circuit here. And just like the judge explained to you about voir dire, jury selection, I'll just be asking you some questions. And I just want it to be a group conversation, be comfortable, and I'll call on some of you personally, and then some I'll just open up to the group and you can just raise your hand and I'll call on you. And before I start, my seating chart is I do have a seating chart, so it'll help me with the names, but I see Miss Shields, and I think, is that you? That's what I thought. And then Miss Kalmanson, that's you, okay. Thank you. Okay, so what I'm gonna do first, I'm gonna start with your forms that you filled out and just gonna go through some things on there and ask you specifically those questions. Miss Potter, I see that you listed a relative as a victim. Who's that relative?
That would be me.
Okay, and what were you a victim of?
Somebody broke into my home and stole jewelry and cash.
Okay, and was that long ago?
2005.
Okay, and would that have any bearing on your participation in today's criminal trial?
No. It was a bad experience, and I'm not sure how that would affect me in making a judgment. So
Okay.
it just,
Well, as a judge,
I felt like a victim.
yes, ma'am. And as the judge instructed you all, this is a driving under the influence. I'll refer to as DUI, short form. And so that is the case today, which isn't a burglary. Does that change the way that you would see your participation as a juror since you were a victim in the past?
I would have to answer no. I don't believe that would affect the way I feel about looking at a case like this.
Okay, thank you. And Miss Ellis, I see that you listed your child as an attorney. What type of law?
More civil law.
Okay. Did that child ever do criminal?
No.
Okay. And Miss Lozano? Is it Miss Rico Lozano or Miss Lozano?
I just go by these three.
Okay, great. And I saw that you listed victim. Was that you or a relative?
Me.
And what was that crime?
Somebody tried to break into my car while I was in
Oh, wow, okay. And how long ago was that?
last month.
Okay, and I'm sorry, we don't have a victim in today's case, but would that affect your ability in a DUI criminal trial, your experience? No, okay. And I also saw your spouse's occupation was, your spouse is self-employed. What kind of business is it?
Landscaping.
Okay. Thank you very much. And then Mr. Hornbach, did I say that correctly?
You did.
And I saw that you are an attorney.
That's correct.
What kind of law do you do?
I have a general civil practice, practice mostly in probate, wills and trusts,
Okay.
real estate.
Have you ever done criminal?
I started to career in criminal defense. I was waiting to pass the trial.
Okay. And was that all your experience in criminal?
That's correct.
Okay. And what kind of cases did you look at that time?
At that time,
Yes, sir.
first degree murder.
Okay. And I saw that you listed victim on your sheet.
That's
Who
correct.
was that?
Myself,
And what kind of crime?
I was a battery victim and victim of theft. My parents were victim of theft. And my mother was injured in an automobile accident. DUI.
Your mother?
That's correct.
And how long ago was the DUI with your mother?
Probably 20 years.
And is she okay now?
She's deceased.
Was that a result of the DUI? Okay. I'm sorry to hear that. And would the fact that your mother was a victim in a DUI, would that have any bearing on your participation as a juror today in this DUI case?
No.
Okay. And then how long ago was the battery and the theft that occurred to you?
The theft was approximately 2 years ago. The battery was in high school.
Okay. And then your parents' thefts, how long ago was that?
Same. It was the same.
Okay. And so would any of those crimes that occurred against you, would that have any bearing on your participation in being a juror today? Okay. And also, one more question for you, sir. I saw that you said your hearing is fair. Is that, if you're sitting over here, would you still be able to hear everything clearly if we speak about this decibel?
Yes, the attorney, judge, and witness all speak clearly.
Okay, great, thank you. All right, Miss Esala, did I say that correctly? Esala, I'm sorry. Miss. Okay, cool. Miss Esala. Okay. I saw that you wrote a recruiter. You are a recruiter? Okay. I just was curious as to what you were recruiting for. Thank you, ma'am. And Miss Fitzgerald, I saw that you wrote a relative or someone in your family was arrested of a crime. Who was that?
My ex-husband at the time.
How long ago was that?
2017.
And so I heard you say ex-husband, so you're not with him currently?
Correct.
And were you in any way related into that DUI?
No.
Okay. Did you sit in the criminal trial did he have a trial?
I don't remember.
Okay.
We were going through a divorce at the time too, so
Okay.
I didn't, if he did, I was not.
What happened to your husband, would that affect your participation today as a juror in a DUI trial? Okay. And was he guilty of the DUI in 2017? Okay. Thank you, ma'am. Miss Martinez, hello. I saw you wrote ESE, assistant requested?
For exceptional student education, I work with students with special needs.
Okay, great. I was just curious what that stood for. Thank you. And Miss Witcher? I saw you wrote LEO in the family. Who is that?
I have a cousin who's a YRD deputy in Highlands County.
And is he still currently?
Yes.
Okay. And you'll hear the judge instruct you today about law enforcement as witnesses, that the fact that a witness is employed in law enforcement does not mean his testimony deserves more or less consideration than that of any other witness. Would you be able to follow that law today because with your cousin being in law enforcement? Okay. And I'll open that up for everybody else here. Does anyone disagree with that statement of the law right there that I just read about law enforcement as witnesses? Okay, no hands raised. And also, Ms. Switcher, I saw that you wrote victim on your form. Who was that?
When we were burglary about 2008, 2009. Not in this state though. We were in Texas.
Okay. And were any of you hurt?
No.
Okay, that's good. Just financially, okay. And would the fact that you were a victim of the burglary, then would that have any effect on your being a juror today?
Yeah, my daughter was also hit by a truck driver,
Okay, thank you for sharing that.
but he was not fined in it. So he didn't have a license. So he was cited for not having a license and failure to stop at a stop sign.
How long ago was this?
A little over a year ago in Lee County,
Okay.
less than a mile from her house.
Okay.
Her car.
Was she okay?
She had some medical things to deal with, but she's gotten through that.
Okay, that's good to hear. Would the fact that your daughter was a victim of a DUI, would that have an effect on you today, hearing the facts of this case being a DUI?
I'd like to think not, but it could be a possibility. I don't know. It's very traumatic.
And would you be able to follow the law that the judge instructs you if you're chosen as a juror?
I would hope so.
Okay. And then one more question for you, Ms. Witcher. I saw you wrote someone was arrested or accused.
I have a niece who has been arrested, I think, multiple times. I don't really have that much to do with her.
Okay.
She lives here in Collier County, but mostly drugs and that.
Okay, so that the fact that your niece has been arrested multiple times, would that affect your participation today in this trial? Okay. All right, thank you, ma'am. And Miss Tantuico? Mr., I'm sorry. Did I say that correctly?
Yes.
And I saw that you wrote that you would like to request to be excused. Is there, like, if you were chosen as a juror today, would you need to, is that going to be a problem? And if you were chosen as a juror today and possibly for tomorrow, would you be able to concentrate on the case at hand when you're thinking about missing work and the bills that you have to pay?
Maybe, but in addition to that, the rest of the case, I've experienced the situation all the time.
So how long ago was that with your best friend? Okay. And was he harmed in that accident? Oh, I'm sorry to hear that. Okay, so, and you just said that if you're chosen to be a juror today, and obviously this DUI case, do you think that you would have an issue being able to be fair and impartial, like you just said? Okay. And And I saw that you wrote victim. Is that what you were talking about?
Yeah, also house burglary, being
Okay. And how long ago were those?
several years ago.
Okay. And would those particular crimes have an effect on your ability to participate in today? Okay. And then one more question. I saw you wrote hearing and sight is fair. If you sit over here, is that
I
gonna?
just have tinnitus, you know, 18 years.
Oh, okay.
So I don't feel it.
Okay. And what about your sight?
I got 8 glasses.
Okay. Thank you. All right. And Miss Shields, you wrote ESC teacher as well. Is that the same that we heard earlier? Okay. And then I saw you wrote health, hearing, and sight as well is fair. Is that going to be an issue today? Okay. Yes, ma'am. Okay. I'm sorry to hear that. How long ago was that? Is he okay now? I'm sorry to hear that. Would that happening to your father, would that affect your ability to participate in today's trial in any way? Okay. Thank you for your honesty. I appreciate that. And finally, Mr. Hassler. Did I say that correctly?
Yes.
Okay. I saw that you wrote spouse is in the magistrate office. Is that here in Collier County?
Yes.
And does she do any criminal cases?
No.
Okay. And is she close with anybody in the state attorney's office?
No.
And what about in law enforcement, the Collier County sheriffs, anything like that? Okay. And I saw you wrote victim on yours as well. Who is that? I saw you wrote victim on your form as well. Who is that?
That was my relative. My brother-in-law got stabbed in New York.
How long ago was that?
It's been about 25 years.
Okay. And would that have any effect on your participation today as a juror in this case?
No.
And I saw you wrote arrested or accused for a relative. Who is that?
DUI in 1995.
Who was that for?
Who was
that for?
me?
Okay. And were you convicted of that in 1995?
Yes, I was.
Okay. And did the law enforcement in your case treat you fairly, in your opinion, at that time?
Yes.
Okay. And did you have a trial?
Do I have a child? Yes.
Did you have a trial for the DUI?
No.
Okay. And did you have any issues with the state attorney's office at that time in your case?
No.
Okay. And would your participation today, based on your past experience and in the DUI, would that affect anything in you today?
I don't think so.
Okay. And then one more question for you, sir. I saw you wrote hearing fair. Is that going to be difficult for you today if you're in the juror box there? Okay. Thank you, sir. All right. So now I'm done with the forms and okay, so now we can get into a little bit of what we're dealing with today, DUIs. So the state has two ways of proving under the influence portion of the DUI. We have the ability to use a breath test, blood test, or signs of impairment. Now, let's see. Ms. I, do you agree that there are two ways for the state to prove, just like I just told you? Okay. Ms. Potter, do you agree?
Can you repeat this question?
Yes, ma'am. So just agreeing with the two ways for the state to prove driving under the influence with blood breath test or signs of impairment.
Yes, I agree.
Okay. And the judge will instruct you today that the state is not required to have a breath sample. But we can, again, like I said, show through signs of impairment that someone is driving under the influence of alcohol. Now, Ms. Ellis, do you think that's fair?
Well, I think if it's just signs of impairment, it could be a medical issue.
You're right. That would be a defense. But for the question of not having a breath test or a blood test to show blood alcohol content and just signs of impairment, do you think that would be fair?
Just signs of impairment.
Yes, ma'am. Okay. And why is that?
Again, I think there could be multiple reasons why you might show signs of impairment. It seemed to me you'd have to have some science behind it.
Okay. And so today, when the judge instructs you on the law, would you struggle finding someone guilty without a breath test?
Probably.
Okay. Thank you for your honesty. I appreciate that. Ms. Lozano, what about you? What do you think about what I asked?
I agree. You can do it just by see that they're there.
So you agree with the fact that the state not showing a breath test and just signs of impairment, you would agree that that's fair? Okay. Mr. Stallman, what about you? What do you think about that? Okay. So you would struggle finding someone guilty based on just signs of impairment and no breath test, even if the judge instructs you that the state's not required to show a breath test? Okay. Is there anyone else here, if you could raise your hand, that would agree with Mr. Stallman and Ms. Ellis on not being fair with not having breath test? Okay, Mr. Tensuico and Ms. Martinez. And I thought, oh, I see Ms. Kalmanson. Okay. Did I miss anybody else? And Ms. Cindric? So all of you who raise your hand, you would struggle finding someone guilty without a breath test. Is that correct to say? So you're saying it depends on the signs of impairment that you would see,
Right.
that we would present to you. Okay. And that's fair to say. So let me ask you this. With blood and breath, you have to blow into a breathalyzer and you would have to give your blood. No one can force you. Would we all agree that no one can force you to do those two things? Okay. And so let's say the state could only use breath and blood to prove a DUI. And people aren't forced to do that. So if someone just says, well, no, I don't want to do that, do you think it's fair that that person just gets off from a DUI?
What's the objection based on? I'm sorry? Overruled.
Mr. Hornbach. So what I was just explaining there, do you think it'd be fair if we only could use breath or blood to prove a DUI? And if someone decides, no, I don't want to give a breath or a blood test, do you think it's fair that they would get off free from a DUI since they just didn't want to provide it?
I think it would be difficult to prove that person guilty beyond a reasonable doubt.
Correct, because we couldn't prove anything at all because we didn't have the test.
Correct.
So that means pretty much everyone could go free from a DUI if they just didn't want to give a breath or blood. Correct, and that's why we do have the signs of impairment, because we can't force people to give a breath or a blood test. Does anyone else have any opinion on to what Mr. Hornbach was saying? Anyone like to add anything to that? Yes, ma'am.
I would like to know what are the signs of impairment that are usually considered?
Yes, ma'am, that's a very good question. So just like the judge read to you earlier in the charging instrument, he read that when infected to the extent that his normal faculties were impaired. So what would you say normal faculties of a person would be?
Probably they would articulate, knew where they were located, maybe cross state line. I don't know.
No, those are all great examples. And so based on what you just said, if you saw signs of impairment in those normal faculties that you just listed, and I know we kind of just switched gears a little bit, but if you didn't have a breath test and you saw signs of impairment in someone's normal faculties, would that be enough for you to find them guilty of a DUI?
Probably after I questioned if they had any other issues going on.
Correct, okay, thank you. Let's see. And let's see, Mr. Paul, what do you think about that? What I asked Mr. Hornbach when I asked if the state could only have a breath or a blood to prove a DUI, and we couldn't force that person to take the test, do you think it would be fair for them to get off free from a DUI? Do you think it would be fair that pretty much anyone who just doesn't want to give a breath sample or a blood test, that it would be fair for pretty much anyone to get off from a DUI? I'm sorry? I heard blood test. I didn't hear the first part. I'm sorry. You don't understand the question? Okay. I'm sorry? It's your first time here?
Yeah.
Okay. Are you able to hear me okay? Okay. Now let's move on to what it means. Well, let's think of someone who's had a little bit too much to drink. What are some adjectives that you would describe people that you see that have had too much to drink? Ms. Patel. I'm sorry? Sloppy? Okay. Ms. Sindrick. I'm sorry? What are some other definitions of drunk, maybe? Ms. Lozano, that you think of when you think of someone who has had too much to drink? Okay. How about hammered, plastered?
Slurred speech,
Yes, ma'am.
immobility.
So, you know, there are many definitions of describing someone who's had too much to drink. Wasted, plastered, juiced up, lit, I think is the trendy one today. So today, though, the state does not have to prove to you that someone was drunk driving. Today, the state just has to prove that someone was impaired. And again, the judge will instruct you on that as we get to that and understand a little bit more. Now,
5 minutes, Ms. Santini.
I think I'll have to have 10 more if that's okay.
All right.
Mr. Cruikshank, did I say that correctly? So you wear glasses. If you were to take them off, would you be able to see me still? Would I be blurry? Am I blurry? Am I a blob?
You're not as clear as if I have them on.
Okay.
But I mean, like you said, they got everything on.
Okay. So without the glasses, you don't have 20/20 vision, right? So would you say that without the glasses, your vision is impaired? You don't have full possession of vision. Is that fair to say?
My question is, I guess we're living in a day and age where a lot of words are being thrown out and accusations are being made, but there's no common definition to the term. So I would probably I don't know if your term definite of the term would be the same as what I would think, or what I would the word term. So as long as we're talking about the same definition, I will be much more comfortable giving feedback.
Of course.
To what the term means.
And thank you, and that's a very good point. And the judge will instruct you all today on the definition of impairment. And so that way you will all be on the same page on what you are judging impairment on, okay? All right, and so now I want you all to think of a few people that you saw recently that had a little bit too much to drink. And some of you already mentioned some things earlier. And think of the things that you noted that you could just tell that they had too much to drink. Ms. Potter, what are some of those signs that you saw, you observed?
Maybe talking loud.
Okay. Maybe talking too much,
Maybe talking too much.
depending on their personality, if they're usually quiet, maybe.
Right.
Okay. Miss Ide, what are some signs that you saw of someone? What about TV? You've watched TV, I'm sure, and movies. You've seen people who've had too much to drink on TV.
Then they're just pretty obnoxious.
Okay. Ms. Lozano, what are some signs, maybe not with speech, but with the way that they are walking? What are some signs you can tell that they've had too much to drink? Okay. Mr. Stallman, what about you? What are some signs that you've seen from somebody that has had too much to drink?
Maybe a little unstraight, trouble walking, swearing for words.
Okay. And so you all did well on the physical examples. There are also eyes. You can tell sometimes red eyes. Maybe there's odor of alcohol in their breath, flushed face. Someone said slurred speech earlier. Poor balance, lack of coordination, talking too much, talking too loudly. What about some mental signs, Mr. Hornbach? What are some mental signs of someone that has had too much to drink? If you're having a conversation with them, let's say.
Yeah, it's their inability to carry a common thought, consistent thread of conversation.
Okay. Trouble telling a story, maybe keeping things straight, keeping facts straight. Would that be fair? Okay. That's a good point you made, sir. And all of you that said all these signs, did you have a breathalyzer for them to breathe in that night to see if they had any alcohol in their system? No, you just saw based on everyday experience, right? Is that fair to say? I see a lot of people nodding. And did any of you have any training in DUI detection? No. Okay. Yes, sir.
Law school.
Oh, well, okay, law school. Got it. Okay. So now, and what about driving signs? Ms. Sindrick, have you been out on the road and you saw someone driving and thought maybe they were under the influence of alcohol?
Yeah.
And
Swerving or driving really slow or.
okay, maybe inconsistent speeds. Okay. And let's see. So we've all talked about just the ability to function, ability to maybe judge distances on driving, multitasking, like Mr. Hornbach mentioned, with talking, telling a story, maybe just like self-awareness, where they are, what's going on. So are you all aware that on your driver's license, there's a little sentence on the first part or on the front that says operation of a motor vehicle constitutes consent to any sobriety test required by law? Is anyone here did not know that was on their driver's license? Raise your hand. Okay, so if you want to pull it out and check me, you can, because it is there. Everybody has it that has a Florida driver's license. And I'm not sure about out of state, but it's on there. So is there anybody here that thinks that's not fair, that that's on the driver's license? Raise your hand if you think it's not fair. Okay, no hands raised. Now, Ms. Potter, is your driver's license very important to you?
Yes,
Do you use it every day?
yes, I do.
Okay. And Mr. Paul, do you find your driver's license very important to you? Okay. And let's say if you didn't have it for 6 months, would that be a problem? Would that make things difficult for you? Yes. Yes or no? Wait, as far as, okay. And Ms. Patel, if I were to offer you $500 to have your driver's license for a year, so you wouldn't have it for a year, would you accept $500?
No.
Why? Okay. Ms. Esala, if I were to offer you $100,000 for your driver's license for a year, would you take that? No? But you'd have $100,000. Okay. Okay. So can we all agree that your driver's license is very valuable? You can't go without it. Okay. All right. And I'm trying to tie up here, Your Honor. Let's jump to November, Thanksgiving. We all get excited about that time. I'm pretty sure everyone here celebrates Thanksgiving. We love the food. We have leftovers. We eat every day of the week and even the week after. And then let's say the morning you go to work on Monday, you put on your work clothes because they're not as comfortable as your PJs. They feel a little tighter. You walk into your bathroom, you see your scale in the corner, and Ms. Ellis, do you want to step on that scale after you've had all that food for Thanksgiving? And why don't you?
Because I already know what it's gonna say.
Okay, so you're afraid to get on that because you just don't want to see the number. Okay. And Ms. Lozano, what about you? You don't want to step on that scale because you just don't want to know that it says, oh, you had, yes, okay. I just want you to remember that illustration if you are chosen for the jury. And finally, one more illustration and I will be finished here. Let's say it's 4th of July. You have friends over, you're grilling out. You have a baby, 1-year-old in a playpen in your kitchen. You are marinating filet mignons. You have it on a plate on the kitchen counter. You also have a German Shepherd who loves filet mignons. So your friends are out on the patio, you go outside, turn on your grill, you come back, you find the plate on the floor, some steak juice on the floor, but no filet mignons. German Shepherd's missing, baby's in the playpen. What happened to the steak, Mr. Stallman? Okay, and it'd be reasonable to say that the German Shepherd took the steak, right? Mr. Cruikshank, what if a stranger that you never talked to, neighbor across the street, came in through the house, took the steak? Would that be reasonable? No. It's possible maybe, but not reasonable, right? Okay. And Ms. Sindrick, what if the 1-year-old baby got out of the playpen and took the steak? Would that be reasonable? That's probably not even possible, maybe imaginative? All right, so that's just an illustration of reasonable doubt, because today the state has to prove to you the elements of the crime beyond a reasonable doubt. And I'll leave it at that because I did take up a little bit too much time. And so no further questions. Thank you all for your time and your attention. I appreciate it.
Thank you, Ms. Santini. All right, Ms. Armpriester.
Good morning, everybody. My name is Carrie Armpriester. It's my privilege this morning to defend Mr. Smith. Right now, it's my job and the only time that I will get to be this informal with you. So I'm going to try and get to know you a little bit, kind of follow up on some of the state's questions. I do have a bit of my own. I'm going to switch things up a little bit. So if you want, I know that was long. It talked about a lot of coverage. If you want to stand up, shake it off a little bit, take about 10 seconds, feel free. I know those church pews are not that comfortable, so do what you got to do. Also, please understand that I'm not trying to pry into your lives. I'm just trying to make sure that you are the best fit for my client's jury. If I ask a specific question to someone that you're like, hey, Ms. Armpriester, I would like to add to that, please feel free, jump in. Just don't wait for me to call on you if you think you have something to add. So first, before I get into my own questions, the state focused a lot on what's fair and is that fair? But that's not the standard today. The standard is that they prove the case beyond a reasonable doubt, not what's fair. Does everybody understand the difference? I see some heads, but Miss Martinez, what's the difference to you between, well, is that fair, and what the judge instructs you on the law and the standard?
I don't think the law is, fair isn't necessarily the law. I know earlier we talked about, you know, taking a breathalyzer, and that you don't necessarily have to take one, but would it be fair to get off? If you don't, well, you don't necessarily get off. It's about proving beyond a reasonable doubt. So.
And who agrees with Ms. Martinez that this notion of fairness goes out the window? It's about what the state can prove beyond a reasonable doubt. And it's not what the defense can prove. The defense, technically speaking, I can sit at that table and play Sudoku with my client. I'm not going to do that, but I can do that and still meet my burden because I don't have one. Who has a problem with that? That the defense doesn't have to put on one shred of evidence today, and still I'm compliant with the legal burden. All right, we all paid attention in civics, or agreed with civics, I guess. In terms of that notion of it's the state's burden, and they will tell you that they welcome that burden. They know what they're getting into when we do this. Not saying anything that they don't already know or aren't okay with. On that notion of fairness and their burden, does anyone have an issue with Mr. Smith not uttering a single word through this trial? Does everyone understand that he does have the complete and utter right to remain silent? I see full heads shaking, so if there's anyone that does not respect and protect his right to remain silent, would you please show your hand? Okay, on that though, and this is a different question, and someone said earlier words and definitions mean things. You may understand he has that right and respect that he has the right to remain silent, but who's like, no, still got to hear from him. I'm definitely going to hold it against him if I don't hear from him. Mr. Hassler, are you okay if my client doesn't testify?
I'm okay with that.
And Ms. Shields, do you need to hear from my client?
I feel like because of my past, I didn't see that guy. He was let go after a month. It's a third world country, was in a village. I would have loved to hear.
So is it, and I apologize, I was actually meaning to, I know I called your name, that was my mistake. I didn't mean to bring up a traumatic incident for you. Even though that was in a different country, go ahead and get it out of the way. Would you agree that this is not the best case for you to sit on as a juror? And that there's no way that you can be fair and impartial to this particular case? I understand. Miss Witcher. You shook your head that you understood that my client has that right. Do you still need to hear from him?
I understand that he has the right. I just feel like you're your best advocate. I know you're an attorney who represents him. You are his advocate. I think too, I understand the right. I understand what you're saying. He has a right to remain silent. I get that.
So you'd like to hear from him, but you're not going to hold it against him.
Right.
I understand that. What about Ms. Patel? Do you need to hear from my client, or just it'd be great if I heard from him? Doesn't really one way or the other. Okay. What about Ms. Cindric? Okay. I'll move on from that aspect. Another thing I want to talk about. The state did mention, I saw a couple people pull it out all over on your driver's license. You were asked, even if you were offered $100,000 for your ID, most expensive fake ID ever, right? You can't sell something that's not sellable. And in terms of the state's example of getting on the scale after Thanksgiving, I don't know about the guys in the room, but how many of you ladies, after those 2 weeks after Thanksgiving and we're into New Year's and we're riding the Peloton and doing the thing, we get on that scale and it's like all my hard work is not paying off? How many has that happened to? I see a lot of we all understand, no matter how hard we're working out, no matter how much we're starving ourselves, how much we're skipping happy hour, we get on that machine and it says, sometimes the number's even higher. So how many people, even if the state's already said they don't have a sample, however, there's a reason people don't always trust machines regardless of certain facts and circumstances surrounding it. Would you agree with that? And Ms. Martinez, I see you nodding your head a lot. Would you like to weigh in on that? Ms. Patel? And that sometimes even your decision to not get on a scale could have nothing to do with what you've eaten or worked out. It could just be, I've had a bad enough day. I don't want to see what that number is because it's failed me before. Ma'am, what's your name in the blonde hair? Oh, there you are. Okay. You mentioned that your ex-husband had a DUI. How much of your, I want to be very careful how I word this, how much of your ability to be fair and impartial on this case is fogged by your ex-husband's experience? Is it fair to say that your ex-husband's scenario could be completely separate and apart from my client's?
Oh, yeah.
And whatever feelings you have for your ex-husband would not be projected onto my client simply because this is a DUI?
Right.
How many people have ever been pulled over by the police for literally no reason? Okay, how many people have ever been on the side of the road and police come up behind you? You're just driving and you see sirens. Sir, Mr. Khrushchev? Tell us about that experience. You're just driving and you see sirens or a police officer or lights behind you. What's your instant reaction?
Nervous.
Instant nerves no matter what. What's usually the first thing that goes through your head? And did you? Officer pulls you over anyway. You pull over, you comply. Has anyone ever been in a situation like that where you did not feel that you were treated fairly by law enforcement? In a scenario where you're pulled over, speeding ticket, what have you, could be anything, or even whatever reason cops come to aid on the side of the road. They give you a ticket, they deal with you. Is that always such a pleasant experience?
Not the initial feeling.
No. Can you?
It almost always has.
Right. Anyone else ever been given a speeding ticket or been cited for something on the roads? Ma'am, Ms. Cindric, what was your experience with that? Okay, but even, and I'm not in any way admitting anything, but even if you were speeding and you get the ticket, were you still really happy with the police officer? Was he nice? Sometimes they're nice.
No, they weren't.
And sometimes that is the case. Anyone ever not have the nicest police officer, maybe, or anyone know a situation where sometimes it can just be a little hostile? Sir, tell me about it.
My girlfriend and I was pulled over one time
So how many, and that's a good example. And in some instances, perhaps a little extreme, he did say it was a small town, but how many people can relate to that sometimes that does happen? People are nervous when the cops are behind them. I was at CVS the other day, couldn't find my ID. It's like, I know I have it. And you know, if that's, sometimes when you're involved with law enforcement, whether you're doing something right or not, it's still very nerve-wracking to be in that scenario. Does everyone understand and agree that perhaps that can be a flustering situation? Okay, so when everyone walked in today, I know a lot of people have thanked you for being here, and I do thank you too, but I think court's exciting. So when people walked in, I guess the reaction is either like, okay, great jury duty, or it's great jury duty. So then you walk into this room. When you walked in, how many people wondered what my client didn't do? It goes to the presumption of innocence that we've already discussed. But what I want to make sure is that everyone understands that just because Mr. Smith is charged with DUI does not automatically mean he is guilty of DUI. Does anybody disagree with that? Like, well, he's charged with something. He got cited for something. What are we even here for? Does anybody feel that way? Miss Asala? Okay. Do you have any opinions on anything that I just said about with his arrest as an evidence of guilt, his merely being charged as an evidence of guilt?
Well, obviously there's an issue. What happened and how he's feeling, otherwise we wouldn't be here with him. So there's a discrepancy sitting somewhere, and I guess what we're trying to do is find out what that is and how it happened.
But just because Mr. Smith finds himself a party to this case doesn't mean he's guilty of the crime charged.
Right, that's my point.
Okay. Does anybody disagree with Missy Sala? Okay, I saw a lot of no's there. Okay, the law. We're gonna talk about the law a lot today. Who can tell me where the law's made? Is it here in a courtroom, or is it with our legislators in Tallahassee? Tallahassee. So even if you don't like the law that's read to you today, you still understand that you have to apply it, right? Mr. Salmon, you're shaking your head yes. And I have to call on people, so you understand that we're not here to make law, we're not here to do, we are here to, you're the jury, should you be picked, you're the finder of fact. You will apply the law that Judge Adams reads to you and apply it to those facts. Everyone is okay with that duty as a juror. Judge, how much time do I have?
You have 15 minutes.
Another word that you guys are going to hear a lot today is the word evidence. And I think people, even lawyers, non-lawyers, we have some lawful people in the room, so many things come to mind with evidence. Well, there's two types that the state can use to prove the elements of the crime. They already discussed it with you. There's direct evidence, there's circumstantial evidence. Evidence isn't always a piece of paper, exhibit A. Sometimes it's witnesses who come into court and there's testimony. Sometimes there's video, actual physical evidence of what we have. Do y'all understand that one is just as valuable as the other? Physical evidence is just as valuable as testimonial evidence. Right? I see everybody nodding their heads. Now, here's where it gets a little interesting. What if you have testimonial evidence, but physical evidence and they contradict each other? What are you going to believe? Miss Martinez? Mr. Cruikshank? You would weigh all the evidence and so that this goes into the credibility of the evidence. You as the jury determine the credibility of that evidence, whether it's a video, whether it's oral testimony, whether it's a prior whatever you consider, you must determine the veracity and the credibility of that. Ms. Santini discussed reasonable doubt, and the judge will read to you what reasonable doubt is. How many people have children? I know we have a couple ESE teachers. Okay, great. Those of you that don't have children, siblings, babysitters, you'll go with me on this. So you're downstairs, you're doing dishes, you're cooking, you're just in the kitchen, doesn't matter, upstairs, downstairs. But you hear a vase break. Now, if you're like my family and you have a new golden doodle and a 1-year-old and lots of adults in and out of the house, any one of those could have broken the vase, and literally anyone could be reasonable. The 1-year-old's high chair is right there. Now, and the golden doodle's just crazy. But how many of you know when you hear glass, it's kid A, kid B, you know, or in your teachers? How many people have an idea of what's happening before you go talk to your kids? Miss Ellis, when you were raising children, something broke, did you have kind of an idea in your head of what was going where, or did you sit everyone down and be like, now tell me your story, tell me your story? How did that work in your house?
It always depends on the situation.
If there was a broken vase, what would have happened?
Most of the time it's,
I like it. Walk me through some more.
well, I mean, a lot of times with kids, they're gonna blame each other, so you get the whole story.
And you would have to listen to what each of them said and then initially draw your own conclusion based on
all the information I have.
and maybe a little common sense.
Absolutely.
Who else? Sir, go. What's your experience with broken vase or? Now I want to hear from you again. You're wearing pink. It's great.
It's hard to say that my daughter has the need for not necessarily icing. So my first thought would be if something's breaking, probably broken several dishes, and probably the only one in the house that would do it. Not intentionally.
But is it reasonable that maybe she's being a good daughter and unloading the dishwasher and the dog came and jumped up from behind her and
Absolutely. How reasonable would it, if I heard something and didn't see it, my first assumption would be, okay, where's the
I am that daughter. Miss Patel, in your house, how do you, I guess, solve the caper of the broken vase? That is harder. So how do you do it? And so what do you do? So there's evidence and you can figure it out. Walk me through your figuring it out process.
Why did this happen? I see this, and I usually have to point it out.
And now, but before you get there and in that room and see the twins, do you know what's happened? Or are you like, it could be anything, I need to see what this is? Does anybody not have a clue, or just wait and be like, well, I can't wait to solve what this one was? Or you all kind of, in your own families, you tend to know? I'm going to go here and then I'm going to come to you, sir. Walk me.
I would have no idea.
Why?
The 8, 6, and 2-year-old things happen, and a lot of times you can look at their faces and see the emotion of innocence or they feel those away. There's a kind of emotion or
So some physical evidence. What about now, but you don't have your mind made up until you examine the scene, so to say. Conversate, yep, that's one good way. Now, who's like Mr. Stallman? Okay, so, and does everybody understand where I'm going with this today? These aren't your kids. You weren't there, don't know what happened. It's so important that you listen to all the evidence and make a determination at the end of the trial, at the conclusion of it. In terms of DUI, Who knows what DUI actually stands for? And in some other places, not Florida, it's DWI, driving while. This is driving under the influence. Ms. Santini discussed with you that it can be proven how they intend to prove their case in the two ways in which the law requires. And we are talking about impairment because in this case, there is not a breath sample. In impairment, we were discussing, again, I'm going to say this a lot, words mean things. You're going to be instructed today that impairment means diminished in some material respect. So I too wear glasses. Ms. Patel wears glasses. Sir, you wear glasses. Here. I wear them so I can see better on the computer. Why I wear glasses isn't why you wear glasses or why Ms. Patel wears glasses. I can drive without my glasses. I could make it through the day without them. I would not say I'm diminished in some material respect without them. That could be different for you. So when we're thinking of impairment and when you apply the facts and evidence as you see them today, who has a problem with that definition of impairment, that it's diminished in a material respect? I know earlier, ma'am, Miss Eid, you said that you don't drink, you don't have friends who drink, you nothing. So in terms of impairment, should you be chosen for this trial, do you have a problem with that definition of what impairment is? And even though you don't drink and you don't associate with those who do you understand that someone could be charged with DUI and it could have nothing to do with alcohol? And just because my client, I know we've already discussed some of this, but you more specifically, just because he's here charged, you agreed that doesn't mean he's guilty, but just because of your feelings on alcohol, would that affect your ability to be a juror in this case? You don't think so? Okay. Something else. Go with me on the days where you get pulled over and the cop wasn't nice, and you ended up getting arrested. But imagine another situation where, and this is all hypothetical, not saying this happened, but then the cop follows you home, and then he wants to come inside, and then he wants to cook dinner. At some point, we all reach limits, right? And even though it does say on the ID that most of us get when we're 16, how many of us have ever reached a limit and made a choice and dealt with the consequences of that choice? I'm seeing some heads nodding up and down. Sometimes it's not everybody does things out of like not getting on the scale. Sometimes it's we've reached a limit, I made a choice and I'm standing by that choice. Standing on the sword with this one. How many people have ever been in that situation? In this scenario, to piggyback off what the state was talking about, not having the breath sample and how on the license you agreed to do that. And that it wouldn't be fair for people to get off free from a DUI for not giving a sample. But how many people agree and understand that there could be numerous reasons that a sample was not given? I see one hand. Is there more than one person who agrees that there could be many reasons that a sample was not given? Sure, and we're limited in jury selection, but at the in trial, you would hear evidence. But how many, for a show of hands, rather than nods, just because I'm getting short on time, understand that there could be many reasons why someone does not comply with a directive, even knowing the consequences?
Good and bad reasons.
Good and bad reasons, yes.
Can I ask you a question?
Sure.
And I guess this is where a little conflict I might have, as far as if that's what's on that license, and you've taken the license, I'm not a big license person, the law, all that stuff, but I do it. But I never knew it was on there to begin with when I got the license. No one pointed out to me it's in small print. But it does say, he was
It's about implied consent. I don't think it's completely irrelevant exactly what it says, but what's your question?
My question is this, is that if operation of motor vehicle constitutes consent to any sobriety test required by law, are you saying that the law doesn't require a sobriety test? I've heard two different things today. I've heard that it's not required, that you give a sobriety test, but that the saying on a license that you're consenting to a sobriety test according to law, and those two seem to be conflict.
I don't actually have an answer for you on that. I would defer to Judge Adams. I don't think that is something that is necessarily relevant to the trial. The only thing I would say to that is we're here under the law of the state of Florida, and it's the DMV that issues the license.
But there's two laws, and they contradict in my opinion.
So the law that we're going to focus on today is the law of DUI and how the state would prove that beyond a reasonable doubt that my client was in actual physical control and that his normal faculties were impaired.
Okay, I'm just trying to, I'm just trying to reconcile
I understand.
the two different, seems to be contradictory in the law.
I understand. And I think we can focus on that a little bit later. For purposes of
Ms. Armbruster,
yes.
you have 5 minutes, and let me say that consent is what it means. Consent. It doesn't say you're required.
Thank you, Judge. So I have 5 minutes, so I'm going to go quick with this. How many people have ever participated in a Mothers Against Drunk Driving march or contributed to MAD? Okay. Would that, Ms. Potter, would that affect your ability to sit in this case?
I used to train high school students using equipment provided by Dodge, of how it would be to try to get them to understand how their reactions would be challenged by drinking.
Okay, and ma'am in the back, what's your last name? And what was your experience with MAD? And would your donations to them affect your ability to be fair and impartial to this case? And how many people here are offended by foul language? Okay, Mr. Hornbach. Now, it's not foul language coming from me. It's not even necessarily going to come from my client. Who is offended by rap music, rap culture. And again, like I said earlier, it's not only questions that make you uncomfortable, these are questions that also make me uncomfortable. If you hear the word fuck numerous times, how many people are gonna be like, I can't even listen to this, I can't even decide this case. Okay, and there's nothing wrong with that, but I need to know who is just completely turned off by foul language. And Ms. Witcher? Even though you don't want to hear it and you don't prefer it, would you not hold it against my client in determining DUI? Okay. How many people would hold the use of foul language against my client? And understanding, how many people understand that sometimes when you're upset, the foul language just really comes out, and it's not always a sign of impairment. Sometimes it's just you're angry. I see a lot of heads. And again, no one's going to hold it against either side of us. I don't want it to be held against the state. There is foul language in this case. You're going to hear it. There's a lot of it, and that's just what it is. So if you have a problem with it and don't want to hear it and can't be fair, raise your hand. Who's familiar with the term fight or flight? And who thinks that's fake, that it's not real? That when you're in situations, you just should act like a robot, normal all the time, be completely reasonable, straight and narrow. That fight or flight, I even think there's a new one now, freeze, doesn't exist. Everyone was mostly in agreement with that.
Ms. Armpriester, do you need additional time?
May I have 3 minutes?
All right.
Who has ever experienced an adrenaline rush before, coming from whatever reason? What was that experience like, sir?
I mean, you just get a little bit more energy, a little bit more strength under certain circumstances.
When you say energy, how can that energy reveal itself?
In strength or just more of a push towards something.
Could you be like just a little hyper, a little more jumpy, a little just more anxious? Who else has experienced adrenaline? And again, all these things, show of hands, we all understand these things can affect every different human being in many different ways. We understand that. How adrenaline affects Mr. Stallman isn't how it's going to affect Mr. Cruikshank, isn't how it's going to affect me, isn't how it's going to affect Mr. Smith. In terms of how many people use Amazon? How many people just love Amazon and think they can do no wrong? How many people, no matter if you were to hear that Amazon was involved in this case, would not be able to be fair and impartial to either side? It wouldn't affect, I'm seeing a lot of head no's. Has anybody ever been in a very serious car accident? What was that like?
I was young, 18, and it was pretty traumatic. 3 people in the car with me, seriously injured, and I was in the backseat as a passenger.
And how did you act after that accident?
I tried to help everyone else along with,
Were you scared?
of course,
Were you nervous?
yes,
Were you upset?
yes.
Were you in pain?
No, I was just very stressed.
Very sure. How many people would say their experience was similar to that? Nervous, stressed, scared? See hands in the back. And I will tie up with normal faculties as the law reads them. The judge will again instruct you on it, but for purposes of voir dire, it's walk, talk, see, hear. The main things that make us human, that which makes us human beings, those abilities. Would everyone somewhat agree that my normal faculties are not your normal faculties? Okay. Is there anything that anyone would like to address before I finish? Anything that I've said, done, you want to follow up on? Maybe didn't think of it in the beginning, but now anything? Okay. If there's anything that we didn't cover that you still think that this is not the case for you, please raise your hand and let us know. I do want to thank you for your time. Like I stated, this was the most informal that I'm allowed to be with you, and it's to make sure that we get the best jury. I do not mean to embarrass anybody with any of my questions, and certainly what I say, what Ms. Santini says, it's not evidence. We're just trying to answer and get the best jury. So thank you so much, and see you later.
Thank you, Ms. Armpriester.
Does someone have a question? Yeah, sorry.
I just think it's always good for the person to say something, we get an idea of their perspective. That's how
Are you saying that it's fair that the person be given an opportunity to speak, or that they be required to speak?
That's a good question.
Because there's a difference. And Mr. Smith will be given an opportunity should he choose to take it. It's just, should he not take that opportunity, would you, sir, then hold that against him? If you weren't to hear testimony from Mr. Smith, would that in any way allow you to not be fair and impartial towards him. And it's okay to have feelings about drunk people and having been around them, but what if you weren't to hear anything about that today? As Ms. Santini stated, they don't have to prove drunkenness, slob kebab, any of that. So if you weren't to have to deal with any issues of that, would that still impact your feelings on Mr. Smith's right to remain silent? And it's okay if it does. Sure. And Mr. Tantuico, based on your experience and what you've stated with not having tolerance for people who drink, drunkenness, your family, do you think that this is not the best case for you to sit on? Okay. And I respect that. Okay. Thank you. Any other last minute questions? Yes, ma'am. Ms. Bach. But now, on that logic, and that could be, but now if I said, Ms. Bach, please take the witness stand right now, and I'm gonna ask you all these questions, would you be the slightest bit nervous or be like, well, maybe I don't wanna do that, or anyone else in the room? How many people initially were even nervous to get up and talk to me? There could be many reasons why someone doesn't wanna speak in public, right? And I get it to an extent. Does anybody relate to fear of speaking in public? Okay. Any other questions? And thank you very much for asking those. I do greatly appreciate your engagement. Thank you. Thank you.
Thank you, Ms. Armpriester. Based on the last couple of comments there, I'd like to just remind everyone that in a criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his or her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any way whatsoever. All right, members of the jury, at this time, we're going to excuse you to the hallway. The attorneys and I will be going through the jury selection process. Please make sure to take everything with you because only those of you selected to serve. Hang on, I'm not done. Sit down. Please make sure to take everything with you because only those of you selected to be on the jury for this case will be called back into the courtroom. On behalf of the parties, let me say thank you for filling your constitutional duty by answering your jury summons for this case. The clerk will let you know if you are excused for the day, or the bailiffs will let you know, or if another courtroom needs a jury panel. Again, thank you, and we'll see some of you back in a few minutes. Now you're excused. You want to go ahead and turn your chairs around before you have a seat? That's fine. Thank you. All right, any objection to any of the instructions that the court has given thus far?
No, Judge.
All right, thank you. All right, how much time do you need before we start the jury selection process?
Probably 10 minutes.
I think we have to have some stipulations for the time.
Okay, all right, we will be in recess until 11:35. All right, we're back on the case of State of Florida v. Jarrett Berg Smith, case number 20 CT 777. All parties are present, including the defendant. All right, I'll start with the state, and first 6 will be in the box. Number 7 will be the alternate. Yes.
We've agreed to stipulated causes, if you want to hear those first.
All right, go ahead.
So juror number 6, Mr. Paul. Number 14, Miss.
Hold on.
Oh, sorry.
Why Mr. Paul?
Because he had trouble understanding, and I don't think English is his first language.
Ms. Armpriester?
I would agree with that, Judge.
All right, juror number 6, Paul, will be stricken for cause. Okay,
One is number 14, Miss Bach.
She was sleeping during my question, Your Honor.
yes, I saw that. All right. Juror number 14 will be stricken for cause.
Number 16, Mr. Tensuico.
Number 16 will be stricken for cause. There are multiple reasons on that one.
And number 17, Miss Shields.
Court would agree, Ms. Shields. Any additional ones, Ms. Armpriester?
Those are all the ones that we stipulated on, Your Honor.
All right, any additional ones from the state
For cause.
for cause?
The state would like to strike number 3 for cause. She said that she could not, she would struggle finding someone guilty if she did not have a breath test.
Ms. Armpriester?
Your Honor, I rehabilitated, or I followed up with her, number 3, Ms. Ellis, and when I followed up with her, she stated that she realized that there could be other issues that would cause impairment and that she would need to see what those signs of impairment were and what the law was on impairment, that she would want to see the evidence of that. So I would argue against a cause for juror number 3 because I believe she didn't understand the question. I believe she didn't understand the question at the time it was asked of basically the question as it was posed at the time was who thinks that the state has to have a breath test in order to go forward, which doesn't go into the other part of the law. So I don't feel like juror number 3 should be stricken for cause. She did state that she would want to see other evidence and see what impairment meant and how that affected Mr. Smith.
And Ms. Santini, my notes indicate that when you asked her if she would struggle finding someone guilty without a breath test, she said probably. I don't think that's a clear indication of whether or not she could be fair or impartial. So the motion to strike juror number 3 for cause is denied. Any additional strikes for cause, Ms. Santini?
Yes, Your Honor. Number 5, Mr. Stallman, he said the same thing, that he would struggle finding someone guilty for, when I asked everybody if they agreed with Ms. Ellis, he was one of them, that he would struggle finding someone guilty without a breath test.
Ms. Armpriester?
Judge, I followed up greatly with Mr. Stallman. I would renew my prior argument as it relates to juror number 3. Mr. Stallman also stated that there was different ways people could be impaired. He would need to know what those methods of impairment was. When I discussed the element of fairness and what the state needs to prove the case, he stated that he would follow the law as instructed by the court and apply that to the evidence put on by the state and be fair and impartial. I would object to being stricken for cause.
And that's what I remember also, Ms. Armpriester. So state's motion to strike juror number 5 for cause is denied. Any additional strikes for cause, Ms. Santini?
Juror number 8, Mr. Cruikshank, he has several issues of bias. He had the issue with the law enforcement not being nice and then being arrested, which he did not provide on his form. But he did state that to Ms. Armpriester when she was questioning him. And what's her name? And So that would be why the state would request him to be stricken for cause.
Ms. Armpriester?
Your Honor, the state is indicating that Mr. Cruikshank was dishonest on his affidavit. That's a bit of a compound question. If you or anyone in your family has been arrested or charged with a crime, when I was asking him about his incident, I don't believe he was arrested, charged with a crime. He did state that the cop had put cuffs on him. He explained a little bit more. I didn't want to have him go in further. I don't believe any of that, based on all the other testimony that he gave, would render him unable to be fair and impartial. He did give a lot of answers. He was very engaged, and everything from my notes indicates that he can be fair and impartial as it relates to this case.
I'm in agreement with Ms. Armpriester. I don't have any notes to indicate that he would not be fair and impartial. So state's motion to strike juror number 8 for cause is denied. Any additional strikes for cause, Ms. Santini?
Juror number 9, Ms. Cindric, she indicated that she would also struggle finding someone guilty if there was no breath test, and she did talk about her experience with law enforcement being rude to her, and so that would be bias. And she also clearly looked like she did not want to be here during questioning.
Judge, I can agree Ms. Cindric was greatly involved with me. I also followed up with her as it relates to the breath alcohol. Her direct quote was, "It depends on impairment. I would want to see signs," which indicates that she would want to see the evidence. As it relates to other questions, she was actually engaged with Ms. Santini when asked what it meant with a little too much to drink, and she said that people can be louder. She also indicated that no part of her involvement with law enforcement being rude would render her fair and impartial to a DUI charge. And I don't believe calling someone rude renders bias in a legal setting.
My notes follow along with Ms. Armpriester's. State's motion to strike juror number 9 for cause is denied. Any additional strikes for cause?
Ms. Martinez, number 13, she also indicated that she would have struggle finding someone guilty without a breath test, and that was it for her.
Ms. Armpriester.
For new prior argument, Judge, Ms. Martinez was very actively engaged when I asked her about the elements and the ways that the state needs to meet their burden. She understood that there was multiple ways of impairment. She was actively engaged when I gave the legal definition of impairment. I also believe Ms. Martinez, juror number 13, I also believe she stated as it related to her job as a special needs student when she was giving an example of reasonable doubt that she could follow the evidence and that none of her prior history would make her not able to follow the evidence in this case. She did not use fair and impartial, but she said she could follow the evidence and the law.
My notes follow along with Ms. Armpriester's. I don't have any reason why that I wrote down to strike her for cause. State's motion to strike juror number 13 for cause is denied. Any additional strikes for cause, Ms. Santini?
Number 19, Mr. Hassler, he did tell us that he was convicted of DUI in 1995, and that would just be bias there because he was the one charged with the crime of DUI in this case.
Ms. Armpriester?
Judge, the state specifically followed up with number 19 as he's the individual whose wife works in the magistrate. He was honest about it in 1995 that he was convicted. He said law enforcement was fair to him. He pled. He said that he would be able to apply the law to this set of facts and that he wouldn't hold his prior DUI against. I also don't believe that just because someone has a criminal charge renders them in any way biased to another case, especially given that it was so long ago. And when he was questioned, he did not indicate that the fact that he was convicted of a DUI was in any way a problem for him to sit on this jury. I don't believe it's a proper for-cause right.
State's in agreement with Ms. Armpriester. The court is in agreement with Ms. Armpriester. State's motion to strike juror number 19 for cause is denied. Any additional strikes for cause?
No, Your Honor, thank you.
Ms. Armpriester, any strikes for cause from you?
Yes, Your Honor, I would like to strike juror number 1 for cause. She stated that she did not drink, did not have friends who drank, had no patience for drinking. I followed up with her at the end and asked if she thought that this was not a proper case for her to be a fair and impartial juror. She had shaken her head no. Given her overall demeanor towards alcohol, I don't believe this is the best case for her.
Ms. Santini?
She did indicate that she didn't drink, but when I asked about signs of impairment, she was able to answer back and respond that she could tell what signs of impairment were. And there was no response from her indicating that she would have any issues with following the law and that I can recall, or anything. So we would object to that, number 1 being struck for cause.
Brief response, Judge?
I don't think it's needed. I think based on you asking her questions if she could follow the law and if she could be a juror on this case and her answers, I'm in agreement with the state. Defense's motion to strike juror number 1 for cause is denied. Any additional strikes for cause, Ms. Armpriester?
Judge, may I respond though to the strike for cause for juror number 1?
Go ahead.
When the state asked her to follow up on what her signs of impairment that she knew were, she stated she didn't know, and Ms. Santini followed up, but I'm sure you watch TV. TV is not real life. She's basing her knowledge of impairment on fiction.
Well, she's going to be receiving the definition of impairment, so based on that definition, she'll be able to decide from the facts whether or not the defendant was impaired. So your
Understood.
motion to renew is denied. Any additional strikes for cause?
Juror number 7, Your Honor, he stated that a couple things, that he couldn't be fair and impartial based on the fact that his mother was in a DUI accident. She subsequently passed away. He also stated that he was offended by foul language. I have no issue with the fact that he was or is a lawyer and clerked for a criminal judge in Michigan long ago. That doesn't have anything to do with this, but mainly the DUI involving his mother and the fact that he stated likely not the best case for him on being fair and impartial. I would ask that he be stricken for cause.
Ms. Santini?
He did state that DUI with his mom being involved as a victim was 20 years ago. And when I followed up on that question, if that would be an issue for him being a juror in today's case, or also when I asked if he could follow the law, he did indicate that he could. And so I would object to striking Mr. Hornbach, number 7, for cause.
And specifically, my notes indicate that when you followed up with him and asked if he would be affected by this case because of that incident, he said, I would not be affected. Defense's motion to strike juror number 5 for cause is denied.
Number 7 or 5?
7.
Number 7, I'm sorry. Juror number 7,
I thought I heard 5.
denied.
Judge, my next for cause will be juror 15. She stated with her daughter or her parent, she was a passenger hit by a drunk driver. Her daughter was a passenger in a car hit by a drunk driver who was not charged, only cited for not having a license. It seemed very fresh. She stated it was very traumatic. She hopes that she could follow the law, but I need more than a hope, especially with, I understand that's her daughter. It's not even a year ago. I would ask that she be stricken for cause.
Ms. Santini?
When I followed up with her about her daughter being involved as a victim in a DUI and whether that would affect her, she said possibly. And I asked her if she'd be able to follow the law today, and she said, I hope so. And hoping is not enough to strike her for cause, so the state would object.
I think this one's a little bit different. She specifically stated that her daughter was involved in a DUI in which the car was totaled. Her daughter had to undergo medical treatment. It was very traumatic. When you asked her if she would be able to serve on this jury, she said, I would like to think so. And when you, or well, I think that was, no, I'm sorry, strike that. It was when you asked her if she would be able to set the events of that out of her mind to be able to serve on this jury. And that's when she said, I would like to think so. And then when you asked if she could follow this law, I would hope so. I think the events and her description of the events of her daughter's DUI crash, as well as in conjunction with her answers, indicate that she should be stricken for cause. So defense's motion to strike juror number 15 for cause is granted. Juror number 15 is stricken for cause. Any additional strikes for cause, Ms. Armpriest?
Yes, Your Honor, I missed one in the beginning, juror number 2. I had asked towards the end about MAD, Mothers Against Drunk Driving. She stated that not only does she donate, but she used to train with them. I would argue that that gives her bias, and I would ask that she be stricken for cause.
Ms. Santini?
The state would argue that that's not biased. She didn't state anything about that giving her any reason to not follow the law in this case or to be impartial in this case. And it just goes to her knowledge of impairment based on the training that she gave the kids. So the state would object to number 2, Ms. Potter being struck for cause.
Judge, and on top of the MAD issue, she's also the 2005 victim of a robbery, and she stated, I was very close to her, she doesn't care for foul language, she wouldn't want to hear it, just all that in conjunction. I would hate to, I believe there's enough there that she has told us to establish bias that she should be stricken for cause.
Well, note, Ms. Armpriester, you also followed up with, is there anyone here who would hold the foul language against your client? And no one said yes.
I understand that.
Including Ms. Potter.
But in totality with the other things, I'm asking that she be stricken for cause.
All right. Defense's motion to strike juror number 2 for cause is denied.
I may have a brief moment, Your Honor.
All right, so that leaves jurors 1 through 5 plus juror number 7 as the jury and juror number 8 as the alternate.
Does Your Honor allow backstriking for preemptories?
Yes. All right, State, do you accept the panel?
Yes, Your Honor.
All right, Defense, do you accept the panel?
No, Your Honor, I would like to utilize a preemptory on juror number 1.
All right, Defense uses its first peremptory on juror number 1. That brings juror number 8 into the box. Does the state accept the jury?
We would like to utilize our peremptory on number 8.
All right, state uses its peremptory on juror number 8. That brings juror number 9 into the box. Ms. Armpriester, does the defense accept the panel?
Defense would like to utilize a preemptory on number 7.
Defense uses its second peremptory on juror number 7. That brings juror number 10 into the box. Does the state accept the panel?
The state would use our second peremptory on 9, Ms. Cindric.
The state uses its second peremptory on juror number 9. That brings number 11 into the box. Does the defense accept the panel?
Judge, may I have a moment to propose?
You may.
Judge, we would like to utilize our last preemptory, our third preemptory on juror number 2.
All right, defense will use its third peremptory on juror number 2. That brings in juror number 12. Does the state accept the panel?
Yes, Your Honor.
Judge, what does this leave us with at this?
So this leaves juror number 3, Ellis, juror number 4, Rico Lozano, juror number 5, Stallman, juror number 10, Patel, juror number 11, Asala, juror number 12, Fitzgerald. Does everyone agree?
Yes, Your Honor.
Ms. Armpriester?
Judge, I am out of preemptories. I would like to chat, may I utilize a challenge clause on juror number 12? Ms. Fitzgerald had stated that her husband had an experience with prior DUI that was during their divorce. Even though she didn't know much about it, she had hoped that she would be fair and impartial as it related to the facts. I also believe that Ms. Fitzgerald had stated that when it came to alcohol and signs of impairment, that she would want to hear from my client, but I don't have notes on that, so I'm going off memory, but I would ask to utilize a cause strike on her as well.
Ms. Santini, response?
There was no indication from Ms. Fitzgerald that she wouldn't be able to follow the law or that she would be impartial. When I followed up with her about her husband or ex-husband, she did indicate that it would not be an issue for her to be a juror in this trial today. So the state would object to Ms. Fitzgerald number 12 being struck for cause.
My notes indicate that after she disclosed that her ex-husband had a DUI in 2017, your question, could she follow the law and be a juror in this case? And her quote was, no problem. Defense's motion to strike juror number 12 for cause is denied.
Yes, Your Honor.
All right. That brings us to juror number 13 as the alternate. The state accept juror number 13, that's Samantha Martinez, as the alternate.
The state would like to utilize our third peremptory and
Actually, it would be your first peremptory because it's alternate. You each get one for alternate.
we would like to, we accept it, Your Honor.
All right, Ms. Armpriester, do you accept juror number 13 as the alternate?
We do.
All right. Juror number 13 will be the alternate.
There's no reason to risk going to a second panel.
Thank you. All right, so again, I've got Ellis, Rico Lozano, Stallman, Patel, Asala, Fitzgerald, and Martinez. State agree?
Yes, Your Honor.
Defense agree? All right, so how much time does each side need for opening?
Roughly 10 minutes, it should be less than that.
Ms. Armpriester?
I would like 20 so I don't have to feel rushed.
All right, could we have the 7 brought down? Okay, thank you.
And Your Honor, is it your plan to start as meetings now or take a lunch recess?
So I have about 4.5 pages of instructions to read. That's in 14-point font though. And I think we'll go ahead and do openings and then we'll break for lunch.
Yes, Your Honor.
Is everyone in agreement?
Yes, Your Honor.
I'll be quick, I promise.
All right, right. Go ahead, Ms. Armpriester. So when the jurors come down, I'll take roll of the jurors, and then I'll have them stand and you'll administer the oath. All right. Okay.
Any way we can slide our tables over?
I think there's room to slide it over.
Yeah. I'll have that. No, I just, it's a little cramped to get for me.
You might move that cord over a little bit too,
This one?
so no one trips over it. Yeah.
Yes, sir. Yes, please.
All right, we're back on the record. State of Florida v. Jarrett Berg Smith, case number 20 CT 777. And we're just waiting on the jury panel. So do we have like a regular mask for them? All right, bring them in.
Your Honor, the jury.
Thank you. All right, thank you. You all may be seated. All right, give me one moment here. Members of the jury, you have been selected as the jury to try the case of the state of Florida v. Jarrett Berg Smith. When I call your name, please let me know that you're present. Don Ellis. Daisy Rico Lozano. You have to say it out loud. Thank you. Lance Stallman. Thank you. Lori Patel. Thank you. Mary Asala. Thank you. Megan Fitzgerald. And Samantha Martinez. Thank you. All right. State, do you agree with the jurors that are present?
Yes, Your Honor.
All right, defense agree?
Yes, Your Honor.
All right, thank you. All right, would each of you please stand and raise your right hand to take the oath for jurors?
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and the evidence? Yes.
Thank you, you may be seated. Anyone having a difficult time hearing or understanding me? Okay, if you have a difficult time hearing or understanding me or one of the attorneys, please immediately let us know so we can correct that, okay? All right, again, this is a criminal case. Jarrett Berg Smith is charged with driving under the influence. The definition of the elements of this crime will be explained to you later. It is your solemn responsibility to determine if the state has proved its accusation beyond a reasonable doubt against the defendant. Your verdict must be based solely on the evidence or lack of evidence and the law. It is the judge's responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of this case may be and to apply the law to those facts. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you should not consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their final argument. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to this case. After the instructions are given, you will then retire to deliberate your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the attorneys, and the instructions on the law from the court. Until that time, you should not discuss this case among yourselves. During the course of the trial, the court may take recesses during which you will be permitted to separate and go about your personal affairs. During these recesses, you will not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell them that you are on the jury, trying the case, and ask him or her to stop. If he or she persists, leave at once and immediately report the matter to one of the bailiffs who will advise me. If during a recess you see one of the attorneys and he or she does not speak to you or even seem to pay attention to you, please understand that the attorney is not being discourteous, but is only avoiding the appearance of some improper contact with you. This case must be tried by you, and only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and the court. Jurors must not conduct any investigation of their own. Accordingly, you must not visit any of the places described in the evidence, and you must not read nor listen to any stories or reports in the media about this case. Further, you must not discuss this case with any person, and you must not speak with the attorneys, the witnesses, or the defendant about any subject until your deliberations are finished. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by the court, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. The bailiffs that you see in the courtroom have a very specific task today that I would like to explain to you. While they may wear a similar uniform to some of the witnesses from this trial, they are not witnesses and have no stake in this matter. They are here to keep our proceedings safe and orderly and to assist you with any matters relating to your security and comfort during your service here. Please do not think them rude if they do not chat with you. Their job restricts them from doing so. If, while you are with us, you have any questions relating to your security or comfort, you may direct that question to one of the bailiffs. If your question pertains to anything else, including anything having to do with this case, you must write your question down and give it to a bailiff, and he or she will deliver it to me to be addressed immediately. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You've already been provided with a notepad and pencil for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take notes with you from the courtroom. During recesses, you're going to leave your notepads on the chairs where you're sitting. And after you've completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed and no one will ever read your notes. You will be permitted to take them to the deliberation room with you once you've been ordered to retire to deliberate. However, if you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. What I'd like for you to do is on each of your notepads on the first page, I'd like for you to write your name. That way we can identify whose notepad it is. Then what I'd like for you to do is flip that page over and begin taking notes on the second page if you choose to take notes. All right. Any objections to any of the instructions that I've read? All right. Members of the jury, at this time, I know it's 12:15 and you're probably getting hungry. We're going to go ahead and allow the attorneys to present opening statements, and then we're going to break for lunch, okay? All right. State, are you ready to proceed?
Yes, Your Honor, it's ready.
All right. Defense ready?
That's right.
All right. You may proceed, Mr. Reb.
Thank you, Your Honor. May I switch to those?
You may.
Good morning. May it please the court, counsel, ladies and gentlemen of the jury. I don't know what's going on right now. That's the response of the defendant in this case, Mr. Jared Smith, gave to Sergeant Munoz, the Collier County Sheriff's Office, and Sergeant Munoz asked him whether or not he wanted a crash report for a crash that the defendant believed that he was in. I don't know what's going on right now. Well, the defendant may not know what was going on that night or that morning. So let me tell you about the testimony that you're going to hear today. Let me tell you about the witnesses that you're going to hear from, who absolutely do know. On the morning of April 25th, 2020, the defendant's 30th birthday, around 3:30 in the morning, Mr. Nikos Love, a privately contracted Amazon Prime semi-truck driver, was driving west on Alligator Alley on 75. Around mile marker 63, the Collier County West area, Mr. Love saw the defendant's vehicle attempting to merge on the I-75 from the west area. Mr. Love, who was in the right lane, seeing that the defendant wasn't slowing down and yield to traffic already on the highway, switched to left lane, allowing the defendant to enter I-75. For the next 5 minutes, Mr. Love observes the defendant's vehicle speeding up, slowing down, getting behind him, getting to the side of him, at one point cutting him off where they almost crashed. And then out of nowhere, speeding off into the pitch black darkness of Alligator. Now, what would happen in the next minute would test every bit of Mr. Love's experience in training as a professional truck driver. Because what Mr. Love saw next ahead of his headlights was the defendant's vehicle stranded in the middle of the road between both westbound lanes, lights off, obstructing traffic. Mr. Love would turn his vehicle, his truck, to the left to try and avoid a collision. And as he's doing so, would see the defendant's reverse lights come on and the defendant start to go in reverse, opposite of traffic on I-75. Mr. Love would safely pull his truck to the left shoulder into a grass field. And now with the smell of burnt rubber and overheated brakes and torn up grass, would get out of his truck and tell the defendant what we all know to be true. I said, kill you. But he killed him. After an argument between the two ensued, Mr. Love got back into his truck, called his dispatch, his company dispatch, as he's required to do, not knowing whether or not he had hit the defendant's vehicle. Mr. Love would then call 911 dispatch, and move his truck from the left shoulder to the right shoulder, where he had always been trained to do. Now, while on the phone with 911 dispatch, Mr. Love would get back out of his truck and go and take a picture of the defendant's license plate. While doing that, Mr. Love would hear the defendant threaten him and hear the defendant say that he was trying to make a U-turn on I-75. Now, after being threatened, Mr. Love would get back into his truck, still on the phone with 911, and move his truck just a bit further up the road near line marker 69 to distance himself between the defendant who just threatened him. And then out of nowhere, just like he did before, would see the defendant's vehicle speed off into the darkness without therein. Now, because Mr. Love was able to get a description of the defendant, his license plate number, description of the vehicle, the on the lookout advisory went out for the defendant's vehicle. And you will also hear testimony today from Sergeant Nunez of the Collier County Sheriff's Office that while he was leaving his patrol area and trying to find the vehicle that the advisory was put out for, he came across the defendant's vehicle, broken down on the right shoulder, no mile marker 90. You'll hear testimony today that Sergeant Nunez observed the defendant to have bloodshot, watery eyes, stumbling, slurred speech, and confusion. And perhaps most bizarre about this entire case, you'll hear Sergeant Nunez state that the defendant thought that he was in Weston, in Broward County. And you'll hear Sergeant Nunez state that the defendant thought he was leaving his friend's house in Weston and going to his house in Pembroke Pines. Trip that should have taken 20 minutes, sent him an hour in the opposite direction. Now, you'll finally hear from Trooper Kevin Hernandez of the Florida Highway Patrol, our state's primary law enforcement agency dedicated to investigating crashes and enforcing criminal conduct on the roadways. And Trooper Hernandez will testify today that after completing his crash investigation and seeing no physical sign of damage on Mr. Love's truck, and compared to the damage that he observed on the defendant's vehicle, there was no possible way that those two vehicles were in crash together. Trooper Hernandez, based on his own observations, bloodshot, watery eyes, slurred speech, stumbling, the odor of alcohol on his breath, would move from a crash investigation into a criminal DUI investigation. As part of that DUI investigation, would ask the defendant, did you consume alcohol the night before, early that morning, it's the 30th birthday? The defendant said yes. Trooper Hernandez would then give the defendant an opportunity to dispel his fears that he was driving under the influence of alcohol by performing field sobriety exercises. And based on the defendant's performance in those exercises, you'll hear that Trooper Hernandez believed the defendant to be operating that vehicle under the influence of alcohol. Trooper Hernandez will finally testify that he gave the defendant one last opportunity to dispel his fears by offering him an opportunity to provide a breath sample. And the defendant refused. And Trooper Hernandez will tell you that after advising the defendant of the consequences of not providing a breath sample, that he could lose his license, be subjected to a fine, and that refusal could be used against him here today, the defendant still refused. Now, while the defendant may not know what was going on that night, the state is absolutely confident that after hearing the testimony today and seeing the evidence that we present to you, you will know what happened that night. We will ask you to return a verdict of guilty for the defendant of driving under the influence.
All right, thank you. Ms. Armpriester?
Thank you, Judge. Please report, counsel, Commissioner. I want to again remind you that what the lawyers say is not evidence, but I am here to also tell you that what the evidence is going to show you today is that my client knew well aware where he was and what was going on that night. When all you're holding is a hammer, everything looks like a nail. Think about that for a second. I'm going to repeat it. I'm going to repeat a few things. Every word Every meaning in this trial means something. There's not fluff or fill. It's all there for a reason. When all you're holding is a hammer, everything looks like a nail. It was my client's 30th birthday on April 25th, 2020. And yes, he was driving from Broward County, as many people do. He was driving from his friends in Weston. He lives in Pembroke Pines to see his girlfriend, who's a resident of Collier County. They were going to spend some time in Sanibel. They were going to celebrate the weekend together. However, it wasn't the weekend he had planned that he actually had. COVID had other plans, and then law enforcement had even more ideas for Mr. Smith. Jarrett Smith is not guilty of driving under the influence of alcohol to the extent that his normal faculties were impaired. I'm going to say that again, because again, words mean things. I want you to really listen and see, not just listen, but hear and see all the evidence given to you today. Jarrett Smith is not guilty of driving under the influence of alcohol to the extent that his normal faculties were impaired. You don't just have to take my word for it. I don't want you to even take the trooper's word for it. You're going to see video. You'll get to see some independent, objective video today of how my client behaved after a car accident that you will hear that took place, and how he performed on these field sobriety exercises. Mr. Smith was all set and on his way to Naples from the East Coast. He was on Alligator Alley, and that Amazon trucker rear-ended him. Now, there are pictures today. However, they're not my pictures. They're not in color. They're not clear. And I submit to you that you will not be able to figure out what took place from those pictures. Evidence will show you, again, that Mr. Love kept pursuing Mr. Smith. Mr. Rabb just told you that in his opening, that is what the evidence is going to show you. One way to look at that is that Mr. Smith was actually trying to get away from Mr. Love. Evidence is also going to show you my client drives a small Nissan, and that this Amazon truck, it's not the Amazon Mercedes that delivers my packages locally. It is a semi. You're going to be shown evidence today that indicates how this situation continued to escalate. Again, you'll see photos. They're not very good, but there are photos and video of the damage, but you're not going to see how it occurred. It's just pictures of damage, but no how. Evidence is going to show you that not only did my client drive away and do his best to get to safety, but that he acted in an emergency as best he knew how. A normal faculty. Unfortunately for Mr. Smith, though, the situation got much worse. As he was sitting on the side of the road, he fled safety and his car died. And most of us are familiar with Alligator Alley. The shoulder isn't too big. His car died. He got over to the right side of the road and was calling his girlfriend, Bianca Diaz. You'll hear from her today as well. You're also going to hear a conversation that my client has with her in the back of a cop car. Law enforcement shows up as he's sitting there totally freaked by this road rage incident with a semi in his small Nissan. And law enforcement shows up with their mind made up. I submit to you that the evidence is going to show that Sergeant Munoz, who had the bolo, only had one side story. From the second he gets out of that car, his mind's made up. Pay very close attention to his testimony. His testimony doesn't exactly match up to the video, doesn't exactly match up to a written statement. Pay very close attention to the evidence as he testifies. Pay even closer attention to the video you see. The evidence you're going to see, I submit to you, shows Mr. Smith acting like a completely reasonable person for sitting on the side of the road with their car bashed in. Missing window. It's bad. It's not drivable. Evidence will reveal it was towed away. Trooper Hernandez, while Sergeant Munoz is making contact with my client, Trooper Hernandez makes contact with Mr. Love. and took everything that Mr. Love, the Amazon semi-driver, took everything he said as gospel. He said it, it was truth, it made its way to that report, that's it. After you listen and see the evidence today as it relates to Mr. Love and how it all adds up, I'm confident that you will make the same conclusion that the evidence reveals. Mr. Love has a really big bias and motive to lie. If he were to cause an accident at 4 a.m. with a small truck.
Objection, Your Honor. Counsel's making an argument.
Sustained.
Evidence will show you that Mr. Love totaled a random driver's car in the middle of the night.
Objection, Your Honor. Counsel's making an argument.
Evidence is going to show that, Judge.
Overruled.
Pay very close attention to the evidence that's shown to you. You are the finder of fact. Not only will Mr. Love testify today, but law enforcement will testify, and I suspect that you'll hear from Deputy Hernandez and Sergeant Munoz, and what you'll hear from them is that they did not consider or investigate other possibilities for my client's behavior. Mr. Rabb told you that they did a crash investigation, which led to a DUI investigation. But evidence is going to show you that there was many other possibilities for Mr. Smith's behavior beyond impairment. When you see that car and you hear even Mr. Love's rendition of what he thought took place, evidence will show that there could have been a head injury, adrenaline, so many other things, yet law enforcement remained hyper-focused on one thing: impairment of alcohol. Law enforcement did not consider any objective evidence. You will see that objective evidence today. And I hope that you, unlike law enforcement, does not rely on subjective opinion. Rely on the facts and evidence as it is presented to you. When all you rely on is subjective opinions, hammer, nail. When all you're holding is a hammer, everything looks like a nail. You'll be instructed today by the judge that normal faculties include, but are not limited to, the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and in general, to normally perform the many mental and physical acts of our daily lives. The law does not exist in a vacuum. Evidence is going to show you today that the daily life of Mr. Smith and Mr. Love involved a car accident. Normal faculties are relative to that. I submit to you that the evidence will show that Mr. Smith was very much well in check of his normal faculties and did perform the many mental and physical acts of his life on April 25th, 2020. You don't have to take my word for it. Again, what I say is not evidence. However, what you're going to see and hear today on video and dash cam, big eye in the sky that can't lie. You'll get to conclude for yourself in an objective fashion. And while you may conclude that Mr. Smith was frustrated, anxious, evidence will show that he was talking loudly, that he was all those things, frustrated and anxious. Based on that evidence, you will not conclude that he was impaired from alcohol, nor were his normal faculties impaired. He was acting like a normal person given the situation, not a robot. I submit to you, just as he is sitting here today on April 25th, 2020, he was a fully functioning human being. You each told me earlier that you had common sense, and I'm going to implore you to please use it today. I ask that as you consider each and every bit of testimony and evidence, that you filter it through your common sense. Think of your common sense as you would a coffee filter. You are the finder of fact. You determine what's reasonable. We also discussed that the burden rests with the state and the state alone. They agreed that they carry that burden. I'm confident that the evidence that they are going to present to you today in no way proves beyond a reasonable doubt that Mr. Smith is guilty of DUI or that he was under the influence of alcohol to the extent that his normal faculties were impaired. They don't have the evidence for it. It didn't happen. He's not guilty. Thank you.
Thank you, Ms. Armpriester. All right, members of the jury, at this time, we're going to take a recess for lunch. It is now approximately 12:35 in the afternoon. I'm going to require that you return to the courthouse and check in with the bailiffs at 1:45. The bailiffs will give you additional instructions on where to meet them upon your return from lunch. Before I release you, let me remind you that you are not allowed to communicate with anyone about this case. You cannot use electronic devices to research anything about this case. You cannot go to any location involved in this case. You may not have any contact with the defendant, witnesses, or attorneys, or anyone else involved in this case. If you see one of the attorneys and he or she does not speak to you or even seem to pay attention to you, please understand the attorney is not being discourteous, but is only avoiding the appearance of some improper contact with you. All of us are depending on you to follow these rules so that there will be a fair and lawful resolution to this case. You're going to follow the bailiff out this way this time, and they're going to show you where to meet back at 1:45. So at this time, I'll excuse you for lunch. Thank you. All right, thank you. You may be seated. All right, any objection to any of the rules that I read? All right, thank you. Okay. Do you want to break for lunch and come back early? Or go over jury instructions now or later? Okay. And I don't know if we even need to go over jury instructions yet, since there hasn't been any evidence presented. So.
I can only say that I read them and stipulate to them.
Okay. All right. Well, then let's not do that. All right.
We rotate to them again.
Okay. All right. If I could have you all back here at 1:40. That way we get back here just a little bit before the jury. All right. And then we'll go right into the state's evidence. Okay. Anything else? All right. The court will be in recess until 1:40. All right, no, they're all gone now. It's always up. All right, we're here on State of Florida v. Jarrett Berg Smith, case number 20 CT 777. All parties, including the defendant, are present. Anything we need to address before we have the jury come in?
No, Your Honor.
I'm aware of Your Honor.
All right, let's have the jury come in.
344. Go ahead and bring him in.
As arm priester, I don't know where Mr. Prasure went, but when
I
the,
asked him to.
all right, thank you. Thank you. Thank you. You may be seated. All right, members of the jury, welcome back. We're here again on the state of Florida v. Jarrett Berg Smith, case number 20 CT 777. I hope everyone had a nice lunch break, and I see some of you brought jackets with you, which was probably a good idea. All right, state ready to proceed?
Yes, Your Honor.
All right, defense ready?
Yes.
All right, state, you may call your first witness.
State would call Mr. Nicholas Love.
Sir, if you raise your right hand, face the clerk, please, work, please.
You solemnly swear or affirm that the testimony you shall give shall be the truth, and nothing but the truth.
Okay, so take this with you. Watch your step.
Good afternoon.
How you doing?
May I begin, Your Honor?
You may.
Good afternoon, Mr. Love.
Oh,
Can you please state your name and spell your last name for the record?
I have two last names, so both of them or the last name.
Do both, that'd be fine,
Okay,
thank you.
it's Nikos, Nichos, Love Lunsford, Lunford, Love.
Can everyone hear him okay? Could you get a little closer to the microphone?
How about this? Is it? Okay.
All right, thank you.
And Mr. Love, what's your occupation?
I'm a professional truck driver.
And for which company?
AUM, Amazon.
And how long have you worked there?
Going on 2 years.
Okay. And so you're still currently with them?
Yes.
And do you have to have a special driver's license for driving those types of trucks?
Yes.
And when I say those types of trucks, I mean semis, is that?
Yes.
Okay.
Combination vehicle, semi-truck. Yes.
Okay. And does that require special training to learn how to operate those bigger vehicles?
Yes.
And also, do you live in Collier County?
No.
Where do you live?
Wesley Chapel,
Okay.
Florida.
So let's go back to the day of the incident, April 25th, 2020, almost more than a year ago today. Do you recall that day?
Yes.
And the events that you're about to testify to, what time of day did that occur?
I would say around 2 or 3 a.m. when it first started. It was in the a.m.
So early in the morning.
Early in the morning, yes.
And where were you around that time?
Heading northbound on my way to Davenport to drop my empty off to a Amazon terminal, heading from Miami.
Okay. And so were you on Alligator Alley at that time?
I was on Alligator. I just passed the, I've already passed the toll for Alligator Alley.
Okay. And you briefly just mentioned why you were on the interstate.
Yes.
And to clarify, that was just for your job.
Right.
Okay. And during your time on Alligator Alley, did anything grab your attention on the roadway?
There was a speeding vehicle that came off and came onto the interstate on my right. Usually that happens, but that grabbed my attention, put me in defensive mode.
And where was he coming from?
I believe there was a rest area there, and I believe it was coming from that on ramp from there.
And you mentioned that you became defensive in your driving. Can you elaborate on why?
The reason is most times when I would, in truck driver terms, there's a term we use, four-wheelers, which is people who drive in their personal vehicles. They don't accelerate to the speed limit. So they usually ride the side of the semi truck and then get over in the last second, which causes me to back off or switch lanes or however. In that particular instant, the vehicle was speeding, caught up to me, and decided to come close to my tractor, which made me go to the left. I just switched lanes to the left.
And what did he end up doing when he came up close to you?
At that point, he stayed on the side on my right side for a few seconds, then he switched lanes, and it was back and forth at that point.
Do you remember what type of car it was, the make or the model?
I don't know what year, but it was a Nissan. I believe it was like an Altima or something like that.
Do you remember the color?
It's like gray.
Okay.
Maybe like an off gray.
And is that a sedan?
It's like a small little sedan, yeah.
Now, as we proceed, would images of Alligator Alley help you in explaining what you saw that day?
Yes. I mean, I remember them. They're burned in my head, yeah.
Okay. Your Honor, may I publish demonstrative aids for the jury's sake, and they have been disclosed to defense already?
Any objection?
No.
All right, you may.
Thank you.
Could you pull that microphone up just a little bit? Very good, thank you. Can all members of the jury see the TV screen? Can you see it over here? And Ms. Armpriester, if you need to move somewhere else to get a better view, you can.
And, Your Honor, may I have the witness step down so that he can see?
Yes, sir, you may step down so that you can see the television screen. And Ms. Santini, you might stand so that I can see the screen also. Very good. Yes. You may.
Ready?
Go ahead.
Okay. Mr. Law, is this a fair and accurate depiction of the rest area you were near at that time?
Yes.
Okay. And we see here MM63. Is that mile marker 63?
Yes.
Okay. And so you said you were going to Davenport. So you were going west this way towards the left of our map here?
Yes.
Okay. And I'm going to show you the next image. Is this a fair and accurate depiction of the ramp where you saw the car initially coming from?
Yes.
Okay, and is that towards getting to the end of the ramp?
Yes.
And going west, how many lanes are going west?
There's only 2.
And are those 2 lanes going in the same direction?
Yes.
Okay. And what did you do as you saw the car approaching up off of the ramp coming into the 2 lanes of traffic?
Can I point to the?
Overruled.
Can I point to the where it is?
Sure.
I was here, or right about here, when the vehicle was speeding this way. When we started to catch, we met up at this point. And when the vehicle was here, I moved over. Because at that point, we were gonna ride side by side.
Okay, so were you in the right lane?
I was traveling in the right lane.
And then you had to switch over to the left?
I had to switch over to the left lane when we met to the merging point.
Okay, thank you. And around this time, were there any other cars on the roadway besides you two?
No, that was just me and the other car at that point.
Okay. And after switching lanes to allow the car onto the highway, what happened next?
It was more like trying to avoid being behind the car at that point. The car was, first it was on my right. I was in the left lane and the car was on the right. And it stayed on my right where there's a pivot point where we call the catwalk of my tractor and trailer, where there's a point. He was hovering that point. And then I was already backing off. He got in front of me. I switched back to the right lane. He stayed on the left side of me and then got back in front of me, slowed down, straddled the lanes, slowed even more down. At this point, I'm at 55 miles per hour. So I'm in the right lane. He's in the left lane and then just takes off.
And you mentioned a couple different speeds.
Yes.
What you just explained. Was that car going inconsistent?
No, it was not consistent speeds. It was, like I said, it caused me to go down to 55 miles per hour because the lane switching, and I didn't know where he wanted to do or go.
And just for clarification, on this highway, what's the speed limit?
It's 70.
And did you at any point, were you able to regain your speed back up to the speed limit?
After he took off, there was a point where I got it up to almost 70 miles per hour.
And so then at that point, what happened next?
Almost reaching 70 miles per hour. Can I point again?
Yeah.
You see these separation lines right here where it determines the left and right lane. The vehicle, after taking off, I'd probably say less than maybe almost 30 seconds later, the vehicle was sitting in between.
Let me go to the next housing better. Is this a fair and accurate depiction of around that mile marker
Right.
where you were?
Right.
Okay. And is that about how the left shoulder looked that night?
Well, if you call that a shoulder, yeah. So,
Area.
at this point, I'm still in the right lane, and the vehicle is in the center lane. With its Alligator Alley is really dark. There's really not any lights that'll light up the interstate at that point. So my headlights are the only thing that can tell me what's on the road. And my headlights are only at 300 feet ahead of me. The vehicle is in the center, or sitting at the center divider, with its left tire closer to the center, where the right tire is more out to the right lane.
And did you say, were his lights on?
There was no lights.
Okay. And was the car moving in the center?
No, it was stationary.
And what did you do when you saw that?
Slow. I started to brake, and then as I started to brake, the reverse lights kicked on. And at that point, I'm in the center. I'm also going to the center because if his brake lights are coming on, he started to reverse, which means his car is angled to the right. I'm already defensive going to the left.
And so permission for the witness to use the car on the TV replacement?
Any objection?
Yes, Your Honor.
On what basis? Overruled. Go ahead.
Mr. Love,
Yes.
so this representing the car.
Yes.
Can you place how you just testified to
As far as him being this, yes.
the initial time you saw the car? And we'll clarify when you place it. The head, or sorry, the front of the car would be with these lights.
Oh, I'm sorry.
And for clarification, is this the front of the car
That is the front of the car.
facing west? And then the back of the car is facing east, is that correct?
Yes.
Okay. And so that's the initial position that you saw the car in?
Yes, stationary.
Okay. And then, as you explained before, can you now position the way it began to reverse, which direction that was in? Okay. And then with your finger, can you point the angle that it was reversing in the direction?
It was versing into the right lane, going to the right,
Towards the,
towards the shoulder.
okay. And this, right, with the
As I'm approaching, it was going into the right lane in reverse, going towards the shoulder.
Okay.
But this is where it was when I started to swerve.
And as you were passing by him, where did he end up? Where did the car end up? Thank you. And so when you were in the middle lane that you mentioned before, where did you end up going as you approached him?
I swerved while braking into the grass. Tough. My brake probably ended up right here.
Okay, so was your truck in the grass completely?
I would say my tandems were probably my tandems is what we call the back trailer tires. So my back trailer tires were probably the only ones probably still touching the gravel.
And you can step back and
Okay.
because I have some more questions and that way you can feel a bit more comfortable.
All right, are you finished with the TV?
I have evidence to publish today, so we can put it back, bring it back out for the evidence.
All right, we'll go ahead and just set it aside.
Thank you. And Mr. Love, when you noted that you went to the left shoulder, can you please clarify why you had to do that?
Because if I were going to the right shoulder, I would have collided head on with him. So it's just common sense to swerve out of the way of the object instead of into it.
Okay. And now, after you stopped in the grass, what was the next thing to happen?
Immediately upon stopping, the vehicle was ahead of me. Still parked angled now in the left lane. So I was still in my truck when the vehicle was in front of me. And then I jumped out to meet the driver of the car to see what was going on. That was it.
And so did you see the male that was in the car?
Yes.
Did he step out of the car?
He stepped out the car.
And can you please describe what this man was wearing?
He was wearing like a black t-shirt or a black shirt. At the time, it was like red and black pants, like sweatpants with sandals on.
Okay, and do you remember what his hair looked like, his face?
Scruffy, had a beard, like a lumberjack beard.
And do you recall how old he looked?
I mean, young, like in his 30s.
And do you recall his height? About how tall he was?
I was taller than him, so I'm 6 feet. He had to be like 5'10", 5'9".
And do you see that same man in the courtroom today?
Yes.
And can you please identify him by an article of clothing that he's wearing?
He's wearing a black suit, black tie.
And could the record reflect that Mr. Love identified the defendant, Mr. Jarrett Smith?
The record will reflect.
And what did you see the defendant do after he got out of the car?
The first thing he did was he threw his hands up in the air, like this, and then he kind of went to the side. His left side went to the car, and then he just started saying, "You hit me," with some racial slurs.
And when you said his left side went to the car, what did you mean by that?
It was like he stumbled. I don't know if he was the gravel or at that point. I don't know if he was catching his bearings on the gravel or the street, or I don't know at that point.
And you said you heard him speak. How did his speech sound to you?
More like kind of sluggish. That type of speech.
Okay. Was it out of the ordinary to you?
It wasn't normal.
Okay. And when you guys were speaking, did he mention what he was doing on the road?
He told me he was trying to make a U-turn.
Did he say where?
No.
And did the defendant continue to speak to you?
Just more racial slurs after that, accusing me of hitting him, more on that base.
Do you remember, without specifically with the racial slurs, but do you remember what other things that he said to you that morning? I'm sorry.
Nothing more other than him just trying to tell me he was making a U-turn and accuse me of hitting him, and he's gonna make a phone call and something. He's going to his car. I think that was it.
Were you upset after that?
Well, I was upset at the fact, not because of the racial slurs. It was more the fact that he was blaming me for hitting him.
And so why were you upset? I know you just said that you were upset that he was telling you that you hit him. Was there any other reason why you were upset?
No, I was more worried. I was more worried than anything, because I don't know what just happened. It was my whole career. I mean, I've seen it, but I've never been part of it. And drilling and everything was running. And the thing is, it was just weird how you'll see a vehicle just in the middle of the road with its lights off, and then it just goes in reverse, and then the driver of that vehicle comes out and say, "It's your fault."
And After words were exchanged, did you leave at that point?
At that point, I decided to get back in my truck. I didn't want to go any further than that. I got on the phone with my dispatch after that. So I went back to my truck.
And before you left, in the I don't want to say excitement of the moment, but there was obviously a lot going on. Did you say anything to the defendant?
Other than after he repeatedly accused me of
Overruled. You may answer.
other than the constant accuse me of hitting him, I said I should, with profanity, beat your tail right now because I could have killed you, or we both could have died in that instance.
And when you say I could have killed you, what do you mean by that?
When his car was in the middle of the road with all the lights off, and Alligator Alley is pretty much dark, and then he decides to put his vehicle in reverse. I'm in a semi truck, which is 80,000 pounds. Even though I'm empty, I have a force of a freight train going almost at 70 miles. I'm sorry. I've seen trucks destroy cars as tiny as that. And it goes over the road. I've seen bodies, what a truck can do. And he comes out and blames me.
And I know I asked you after words were exchanged, did you leave? So after that, why did you leave that point?
There was no point of when he started to stumble back to his car. At that point, I determined that he was intoxicated because when we were talking, he just kept trying to keep his balance. So there was no point talking. I've dealt with people who has that same demeanor, so there's no point in having a conversation with them. So I just wanted to make sure that I do my step as my policy was when you're potentially involved in an accident or whatever. If my tractor could have been damaged, even if nothing happened, I have to report that to my dispatch. So I went back to my truck to do that.
Okay, so once you got back into your truck, that was the first thing you did?
That was the first thing I did, was call my dispatch.
And as you stated, is that because of protocol?
It's protocol, company policy.
Okay, and as soon as you did that, what did you do next?
I decided to pull over to the right shoulder.
Why?
It's safer. It's, we're trained. Far as there was no left shoulder, so that's an unsafe area. It's not designated for any particular, let's say, breakdowns or accidents and stuff like that. That's not where you're supposed to be. If your vehicle can be moved, you put it on the right shoulder.
Okay, and so after you moved to the right shoulder, did the defendant follow you?
Immediately.
Okay. And when you got to the right shoulder, what did you do next?
At this point, I'm on the phone with the 911 at this point.
And did you tell the 911 operator everything you're telling us right now?
Yes.
And did you at some point move your truck again?
At some point, I'm in my truck again.
Did you move your truck again?
Yes.
And why did you do that?
The defendant or the driver, the 911 operator asked me to get pictures of the vehicle. And as I exited my truck, he was on the phone. And I can hear the conversation. He was telling somebody on the phone that I have a Glock. Should I shoot him? Should I shoot him?
Let me pause right there. Who had the Glock?
The driver, or the driver of the Nissan.
So the driver, which is the defendant,
Yes.
did he say he had a Glock?
Yes.
And so please continue on with what you're saying.
Well, I told the 911 operator that I just overheard him say he had a Glock and that he was going to shoot me. And so I told her that I was just going to snap the picture. And then I went back to my truck. And then that's when I moved it a little bit ways away from him.
Okay. And how much distance would you say?
It wasn't that far. I'd say like maybe 50 to 100 feet away from him.
And again, why did you make that distance in between you and the defendant?
This time it was like a safety call to get away from the defendant.
And after you moved away a bit, did the defendant follow you again?
He was right behind me.
Okay. And at some point while you were on the phone with 911, did you inspect your truck?
When I moved the truck the second time, or maybe I think this is the third time, I did get out and looked at my truck. It was really dark. And I did inspect my truck.
And why did you do that?
To see did I actually hit, or he hit me, or was there any damage? Was there a collision? It's actually part of my company policy anyway, to inspect the vehicle.
Did you see any damage to any part of your trailer or tractor?
There was no damage to my tractor. There was no damage to my trailer.
And at some point while speaking to 911, did you get I know you mentioned that you took a picture of the license plate. Did the dispatcher ask you to do that?
The dispatcher asked me to take a picture of his license plate.
Okay. Showing opposing counsel, State's Exhibit 1, page 44, discovery. Your Honor, may I approach the witness?
You may.
Mr. Lowe, I am showing you State's Exhibit 1. Do you recognize this?
That is the photo that I took that night or morning.
And is that a fair and accurate representation of the car when you saw it when you took the picture that day?
Yes.
The state would like to offer State's Exhibit 1 into evidence.
Any objection? All right, State's Exhibit 1 will be admitted.
And may I approach it to the jury via the TV, Your Honor?
You may.
Mr. Lowe, step down just to, well, I'm sorry, strike that. You have to-
Okay.
So, that's State's Exhibit 1, just for the jury to see. And, actually, yes, Your Honor, may I have Mr. Lowe step down just to point out things in the picture?
Yes, you may.
Mr. Lowe, can you come back again, please? And when you took this picture, did you notice damage to the defendant's car?
Yes.
And can you please describe what damage you saw that?
It was like his trunk was like he backed into something. Like there was an impact to the back of his car.
And was there anything about the back window that you saw?
There was no windshield.
And were there any other dents that you saw?
Not far as around the other, like around the only right there that I remember.
Okay, so can you please point where you did see the dents in the back?
There was like a impact on the corner. The picture doesn't show it, but there's like huge dent on the left side, and then no bumper, and the trunk is kind of smashed.
Right, so we're fantastic, we can sit that down, thank you. And all of that.
Mr. Love, after taking that picture, you mentioned already that you went back to your truck. What happened next in the timeline?
I was relaying to the 911 operator as far as that I took the picture, and she was asking me questions as far as where his position was and to that nature.
And what did you see the defendant do at that point?
He stepped back out of his car because I'm watching him through my side mirror. He steps back out of his car, and then he stands out to his he's standing into his like in doorway to the car, and then gets back in and takes off.
When you say take off, what do you mean by that?
He got back in his car and proceeded down northbound back on the interstate.
And did he accelerate at a high speed?
Yes.
And did law enforcement ever arrive?
Yes.
About how long after the defendant sped off did law enforcement arrive?
Maybe less than maybe 10 minutes, maybe.
And did you tell law enforcement all that you testified to today?
Yes.
And after speaking to law enforcement, did you see the defendant again after that?
Yes.
And why was that?
They asked me to. They asked me, the law enforcement, they asked me to identify.
Okay. And so when you saw the defendant again, was it just to identify him for law enforcement?
Yes.
And did you indeed identify the defendant to law enforcement?
Yes.
And when you went to see the defendant that one last time, how far up the road from where you were with law enforcement did the defendant end up?
It was almost 20 miles, or if you want to say from the original mile marker, it was like 20 mile markers down, if you want to say 20 miles almost.
Okay. And during this whole timeline that you just testified to, was it just you and the defendant on the road besides law enforcement when they arrived?
Yeah, it was just me and the defendant, yes.
And let's go back to the moment when you were about to collide into the defendant's car, when you first saw it in the middle of the road. When you swerved up and ended up in the left shoulder, you mentioned inspecting your truck and trailer. But did you see any vehicle debris on the roadway where you two were at that time?
No, there was no, there wasn't any collision debris, no broken glass, no tail light or tire or anything.
And you mentioned also that there was no bumper on that picture of the defendant's car.
Yes.
Did you see a bumper at that place?
No.
And initially, did you think that you made contact with the defendant's vehicle?
Yes, because I felt I didn't swerve out of time enough, because two moving objects. He was going in reverse. I didn't know whether or not.
And did you believe that you collided with him after you inspected your truck and trailer?
After I inspected my truck, I felt that there was no collision because there was no scratches, not even paint swap on my tractor. Not my tractor, but my trailer.
And during that moment, when you swerved around the defendant, did you feel a collision?
No.
Did you hear a collision?
No.
Did you have your windows open at the time?
I always drive with my driver's window down.
And at that point of swerving, did you have your engine on or off?
It died during the swerve. So in the beginning, as I was swerving, was on, and you can still hear anything around you, no matter if it's on.
So you just testified that your engine was off, so that makes it easier to hear something from the outside.
Yes.
Is that what you're saying?
Yes.
Okay. And why, I'm sorry if you mentioned this already, why was your engine off at the time?
During,
Overruled.
because I drive a manual, what they call a standard tractor. And during the braking, I was busy trying to steer away from instead of breaking it down to low gear. And it ended up shutting off. If you're not in the proper gear, it kills them, it kills the engine. Not to where it just dies because it's a manual.
Okay. And how long have you been driving big trucks such as semis?
Almost 5 years.
And in those 5 years, if something pushes the side of your trailer, do you feel the trailer move?
It depends on the speed and the position of your truck and where you're standing. Yes, you can.
And how does the trailer move if it's hit from the side?
If it's hit from the side, it'll rock the whole entire rig. You can definitely feel it.
Okay. And so after seeing the condition of the defendant's vehicle and inspecting your own tractor and trailer, did you have any reason to believe that you had crashed into the defendant?
I'm sorry, could you repeat that?
Sure. After seeing the condition of the defendant's vehicle and after inspecting your own tractor and trailer, did you have any reason to believe that you had crashed into the defendant?
No. The way that the trunk, the pattern of the impact of his trunk.
Santini,
Mr. Love, if you could
do you have any response to Ms. Armpriesters' objection?
Oh, just that from his own lay opinion of what he saw that day, he can testify to what he saw and to what he thought with what happened to the truck trailer in the defendant's car.
I'm going to overrule the objection. Go ahead.
Mr. Love, you can continue with what you were saying.
I'm saying the position of where he was reversing, there's no way that my trailer would have impacted straight behind him. It would have ran over at least the side or the back passenger side of his car. So one side would be totally damaged instead of just the straight back part.
And from the initial location of first seeing the defendant come off of the ramp from that rest stop, to the last location where you saw the defendant, did you see any vehicle debris on the roadway in between those two locations?
No.
And based on your interactions with the defendant that day, why did you believe that he, in your opinion, was intoxicated?
The way that, as I stated earlier, when he stumbled back to his car, the way he was talking, that was all I can base that off of. The way he was talking, the way he was walking, carrying himself.
What about the way he was interacting with you?
As far as the sluggish demeanor that he had, yes.
Thank you, Mr. Love. No further questions.
All right, thank you. Defense, any cross-examination?
Yes.
Thank you. Thank you. Thank you. No, I'm good. Thank you.
Good afternoon.
Hello.
Sir, you testified on direct that on April 25th, you were driving your semi, correct?
Yes.
And that it was late You're not sure what time it was?
It was after midnight.
It was after midnight, but you couldn't say exactly when?
No.
Objection, the witness did testify to the time of day.
Overruled.
Sir, the route that you were on was essentially Miami to near Tampa?
No, not in Tampa.
What was the other destination?
Davenport.
Davenport. Where is Davenport?
It's it's off of US 27, close to I want to say where the county of Polk
So somewhere near Orlando?
County, I'm sorry.
Okay. So you were driving from Miami-Dade County to Polk County sometime after midnight?
Yes.
Is that a common route for you?
Not really.
Is that a common time for you to be driving?
Yes.
Do you normally drive after midnight or do you switch it up?
I switch it. Well, I don't switch it up. It's how they give me the schedule.
So, and is there a night shift or day shift that's more common for you?
Not as far as a truck driver. It's no really
So-
night shift or day shift.
So you work nights and days equally?
Yes.
And there's a cap on how many hours that you can be driving?
Yes.
And do you know where you were at with your hours when this accident occurred?
Yes.
Where were you at with your hours when this accident occurred?
About maybe like 40, you're talking about as far as my 72-hour clock?
Right.
Or my drive time clock?
Both, either one.
My drive time clock, I had at least 6 hours until that happened.
And how long were you anticipating till it would take you to get to Davenport? How many hours would the
3.
ride from Miami to Davenport typically take?
About 3.
About 3, okay. And would it surprise you to learn that the initial call made to dispatch was about 3:57 a.m.?
Around about that time.
Okay. And you state in that call to 911 that it was starting to rain, correct?
It was a little bit after, yeah.
And you state on direct that you encountered Mr. Smith on I-75 heading north, right?
Yes.
And you made note on the 911 call to dispatch that you did not see a dent in the back of his car, correct?
Yes, initially.
And when you called dispatch at 3:56, you had advised initially that you did think your truck had damage, correct?
I'm sorry, you keep saying I called dispatch at 3:56.
That's when the information I was given by the state as to when the call was made. Regardless, when you spoke to 911 dispatch, you advised that you thought your truck had damage?
Possible damage, yes.
And you pulled over to check for damage?
Between what time?
Anytime during the
Between
scenario.
the dispatch or the 911 call?
Anytime during the scenario involving Mr. Smith, did you pull over to check for damage?
During the 911 call?
So after your initial encounter with him?
Yes.
And you had advised on that call to dispatch that there was some damage to your trailer.
I thought there was damage to my trailer.
You mentioned to dispatch that your observation was that the tandem had hit his car with your tire.
With my tire?
Correct.
My tandem is my tire.
I'm sorry if I got the terminology incorrect. Do you recall telling dispatch that your tandem hit his car?
Possibly, yes.
And you even state to dispatch around that time that you were so confused as to what was happening.
I was confused because when I looked at my trailer, there was no damage. There was no damage to my trailer. So I was back and forth.
And you also mentioned later on that call that at some point his trunk then had a dent?
When I saw his trunk during the inspection, yes.
Okay. Do you recall telling dispatch about 6 minutes into your call with them that you knew for sure that you hit Mr. Smith's car?
Yeah, during the drilling and that everything was happening.
Okay.
I was discrediting myself as far as the swerve.
But you do recall making that statement?
Yes.
And around, I know you stated you don't recall the specific time, but would it surprise you that approximately 4:20 a.m. is when you were telling dispatch that you were pulling up behind Mr. Smith?
I wasn't behind him.
I'm sorry, that he was pulling up. Strike that entire question. Would it surprise you that around 4:20 you advised dispatch that someone was pulling up behind you?
I couldn't identify them because it was only high beams and amber lights.
Did that person turn out to be Trooper Hernandez?
Not sure.
Were they with law enforcement?
Yes.
Okay. You also stated on direct that you had heard my client make mention of a Glock and that he had a gun. Did you ever see a gun?
I didn't say he had a gun.
Did you, was there ever a gun pointed at you?
No, I didn't say that.
Your testimony on direct was not that you heard my client state that he had a Glock.
He stated that he had a Glock.
Did you see a Glock?
And I stated to the 911, I didn't see a Glock.
Okay. And even after mention of a Glock, despite not seeing one, you still got out of your car to go take a picture of his vehicle?
It was during the conversation. I didn't get out after he mentioned it.
I understand, but
Your Honor, may we approach?
Is there an objection?
It's about pretrial motions that we had spoken about.
All right, you may approach. Members of the jury, feel free to stand up or stretch. And you're going to hear a white noise so that you won't be able to hear our conversation, okay? All right, we're going to take a brief recess, and then we'll continue with Ms. Armpriesters' cross-examination of Mr. Love. All right, so we'll take about a 15-minute recess till 3 o'clock. Okay, all right, thank you. Thank you. You may be seated. All right. Sorry, we're going to take a 15-minute recess. The jury needed a break. Okay? All right. If anyone else needs to take a break, now's the time to do it.
Certainly.
All right.
Appreciate it though.
All right. We're back on the record for State of Florida v. Jarrettberg Smith, case number 20 CT 777. All parties and the defendant are present. Are we ready to proceed?
Yes, Judge.
State ready?
Yes, Your Honor.
All right, if we could have the jury.
344. Go ahead and bring him in.
Mr. Love, do you need some more water before we start?
I'm fine.
Okay.
Your Honor, the jury, thank you.
Thank you. You may be seated. All right. We have all members of the jury present and accounted for. Ms. Armpriester, are you ready to proceed?
Yes, Your Honor, thank you.
Go ahead. Thank you.
Thank you, Mr. Love. I just want to back up just a little bit. We've used some terms, and I think some clarity would be helpful. When we say the term dispatch, we're referring to your company's dispatch system, correct?
Yes.
And when we use 911, we're obviously talking about calling law enforcement 911.
Yes.
And in this case, you called your company's dispatch, correct?
Yes.
Okay. You also stated on direct that your truck is very heavy and you likened it to a freight train.
Yes,
Reasonable to say then that your truck is much heavier than my client's Nissan, correct?
yes,
And you also stated on direct that you have your CDL?
yes.
What does that stand for, CDL?
Commercial driver license,
And what does it take to get a CDL?
training, skills.
Is there a test?
Yes, it's a state law test or
And
state
how
test.
often, I'm sorry, I didn't mean to interrupt you.
It's a state test.
And how often do you have to take that test?
If you fail, then you have to retake it until you pass.
And do you have to renew that CDL very often?
It's pretty much like your driver's license.
So every few years?
Yeah, depending on what state that you got it in.
And yours is in Florida, correct?
Yes.
Now, aside from failing the test, what are some other ways that you could lose the privilege to have a CDL?
If, to give you an example, if DOT
When you
finds-
say DOT, what does Department of Traffic?
Yes, transportation. Yes. If a DOT officer so happens to inspect your truck and they find drugs, alcohol, or anything like that, they can actually find that grounds to take your license. If you're driving under influence in your personal vehicle, they can take your license.
So many things can affect your.
It's more easier to lose your CDL than it is to get it.
Understood. Now, would it be possible that your CDL could be affected if you were involved in an accident while working with Amazon?
Depends on the accident.
If you were to cause an accident, it's possible you could lose your CDL.
Possible.
Can you work with Amazon?
All right, have a seat. All right, good morning, everyone. We're here for State of Florida v. Jarrett Berg Smith, case number 20 CT 777. All parties, including the defendant, are present. Is there anything we need to address before we have the jury come in?
I don't think so, Your Honor. I would just like to preset my laptop up to try and save time.
I think that's a good idea.
Thank you, Your Honor.
Thank you.
May I?
You may. Does either side want me to take roll of the jury or just announce whether or not everyone's present? All right. All right, if we could have the jury brought in. Would each side like to reintroduce themselves to the jury?
No objection, Your Honor.
Okay, all right. So when the jury members come back in, I'll welcome them and then tell them I'm going to let you all reintroduce yourselves again, just so that they remember who you are.
Thank you.
Actually, there might be one issue that we could handle now with Trooper Hernandez. Your Honor, I anticipate that the state's going to want to admit into evidence the photos of the incident of that night. And what's pre-marked is page 28 of discovery. I'm not sure what exhibit number or the composite is with them. Judge, I did discuss this previously with Mr. Rapp. It does have two markings on it that looks like someone circled it, so it's not in its original form. So I would object to this particular photo coming in. The other ones don't have any alterations.
Honor, the alterations to the photos would be an actual alteration to the photo and not simply someone circling a piece on the photo. Nevertheless, the state does not intend to remove the photos through Trooper Hernandez.
Okay, all right, there we go.
Disregard it.
Your Honor, the jury, thank you. All right, thank you. You may be seated. Good morning. I hope everyone had a nice, restful evening last night as we start day 2 of the trial of the state of Florida v. Jarrett Berg Smith, case number 20 CT 777. I'll note for the record that all members of the jury are present and accounted for. Thank you for returning this morning. I'd like to have the state and the defense introduce themselves again to you this morning, just as a refresher of who everyone is. So I'll start with the state.
I'm Nicole Santini with the State Attorney's Office.
Assistant State Attorney Lawrence Rabb with the State Attorney's Office.
Martha Short.
Garrett Smith, we represent Mr. Smith.
All right, thank you, everyone. All right, we left off with the state, and Mr. Rabb, are you ready to call your next witness?
Yes, sir, Your Honor. The state calls Trooper Kevin Hernandez of the Florida Highway Patrol.
All right. Good morning.
Morning, Judge.
May I inquire?
You may.
Thank you. Good morning, Trooper.
Good morning.
Trooper, can you please state your full name and spell your last name for the record?
Trooper Kevin Hernandez, Hernandez.
And how are you currently employed?
With Florida Highway Patrol.
And what are your duties as a Florida Highway Patrol trooper?
My duties as a Florida Highway Patrol trooper is to enforce Florida state laws.
And does FHP, Florida Highway Patrol, have a specific area of focus?
Yes.
And what would that be?
We enforce traffic laws, and we also investigate traffic crashes and resolve any criminal activity on the interstates.
And how long have you been a trooper with the Florida Highway Patrol?
About 3.5 years.
And to this point in your career, what training have you had?
I completed the Florida Highway Patrol Academy, 7.5 months training. And during that course, we learned traffic crash investigations, just any agency-specific training that we do. For example, breath test operator certified, standard field sobriety exercises, and stuff like that.
And in addition to your in-class training, how many crash investigations have you taken part in the past 3 years as a Florida Highway Patrol trooper?
Approximately 200.
And how many DUI investigations have you taken part in?
Between 15 and 20.
And do you arrest everyone that you believe is potentially impaired?
No, I don't.
And how would you make that determination?
Initially, what I do is if I suspect somebody being under the influence, I ask them if they would perform field sobriety exercises. and I initiated a DUI investigation.
And I'd like to now draw your attention to the morning of this incident, April 25th, 2020. Were you on duty that night or that morning?
I was.
And what was your assignment that morning?
My assignment is to patrol Alligator Alley between mile marker 100 and mile marker 25.
And is that effectively what Alligator Alley is?
That's correct.
So a corridor of I-75?
That's correct.
And it's the east-west corridor of I-75?
Yes.
Okay. So mile marker 25, what county is that in?
That's West Broward.
Okay. Mile marker 100?
That's Collier County.
And what is the closest off-ramp, I guess, to mile marker 100?
County Road 951.
So Collier Boulevard?
Yes.
Okay. So while you were patrolling Alligator Alley that morning, did you come into contact with the defendant in this case, Mr. Jared Smith?
I did.
And do you see that individual in the courtroom today?
Yes.
Can you please point and identify him by an article of clothing?
Yes. Blue undershirt and a black suit.
And how did you come into contact with the defendant that day?
Initially, I was dispatched to a altercation involving two drivers on Interstate 75 near mile marker 69.
What was the mile marker?
69.
69. And what county is that in?
That's in Collier County.
And is that where you met the defendant?
I did not meet the defendant there, no.
Who did you meet at mile marker 69?
I met Mr. Love.
And who is Mr. Love?
He's the complainant and also the driver of an Amazon semi-tractor trailer.
And was the defendant present at that location at all?
No.
What did Mr. Love tell you happened?
Essentially,
Your Honor, if we may approach.
You may. Members of the jury, I'll just remind you that when the parties approach, you'll hear a white noise. Feel free to stand up or stretch anything you need to do. All right, overruled. Do you want to re-ask the question?
Yes, Your Honor, thank you. Trooper, again, you stated that you met Mr. Love at mile marker 69. And what did Mr. Love tell you happened?
So initially, Mr. Love told me that he was westbound on I-75. He was within the outside lane, which is the right lane. And he noticed that when he was approaching mile marker 69, he noticed a vehicle traveling in reverse. Mr. Love, what he did was swerve to the left to avoid a collision with that vehicle traveling in reverse. And both vehicles were completely stopped at that point. And both occupants of the vehicle, which were the drivers, exited the vehicle, and a altercation ensued.
And did Mr. Love tell you whether or not he had been in an accident?
Mr. Love, he stated he almost hit the vehicle, but he wasn't sure if he hit the vehicle. He wasn't certain.
Now, while on scene, did you receive any information about the location of the other vehicle, in this case, the defendant's vehicle?
I did. So the vehicle ended up leaving, and I initiated a bolo for that vehicle due to the fact that not knowing if the vehicle was involved in the crash or not, just to confirm. And what a bolo essentially is I give the description of the vehicle that was possibly involved, and Collier County Sheriff Deputy located that vehicle at mile marker 89.
Okay. And mile marker 89 is in what county?
That's in Collier County.
And in which direction from mile marker 69 is that?
That's west.
Towards Naples?
Towards Naples.
Now, did you see any physical evidence in the vicinity of where Mr. Love was at mile marker 69 that a crash had taken place?
No crash evidence.
Did you see any damage to Mr. Love's trailer?
I walked around the truck on scene at mile marker 69. I didn't notice anything.
Okay.
But just to confirm, I didn't notice any damage on that truck. No.
And after speaking with Mr. Love and not seeing any damage to his vehicle, what did you do next?
I asked Mr. Love if he would follow me to mile marker 89 to see if we could identify the other driver of the vehicle and see the damage of that other vehicle and see if a crash had occurred.
Now, you mentioned that Alligator Alley is between mile marker 25 in Broward and mile marker 100 in Collier County.
Correct.
Between mile marker 25 and mile marker 100, how many legal places are there to make a U-turn?
There's 4.
And can you roughly tell us what those are or where those are?
Yes, there's one in Broward, mile marker 49, which is a gas station, the Miccosukee Service Plaza. There's one in at the 35 as well, mile marker 35, which is in Broward. And there's another one in Collier County, which is mile marker 80, and at mile marker 63.
Okay, so 35, 49, 63, and 80.
Correct.
So if the defendant's vehicle was at mile marker 89, he would have passed every single one of those opportunities to make a legal U-turn?
Overruled.
That's correct.
Thank you. Now you mentioned that the defendant followed you to mile marker, or I'm sorry, that Mr. Love followed you to mile marker 89 to identify the defendant. Was he able to positively identify the defendant as the individual driving that other vehicle?
That's correct.
And is that where you met the defendant for the first time?
That's correct.
Can you describe, did you see the defendant's vehicle?
I did.
Did it appear to be damaged?
There was extensive rear end damage, very extensive. The rear window was damaged. The driver side rear quarter panel was also damaged.
And at mile marker 89, were you able to speak with the defendant?
I was.
And what were your observations of the defendant while you were speaking with him?
Initially, when I began interview with the defendant, I noticed the defendant, immediately I could see bloodshot, red watery eyes, slurred speech, inconsistent stories, and a strong odor of alcohol coming from his breath during the interview because I was up kind of close to him. And that's all I can remember for now.
You mentioned that the primary purpose of your agency, Florida Highway Patrol, is to conduct crash investigations, enforce criminal activities on the highway. Did you conduct a crash investigation of the 2 vehicles, Mr. Love's truck and the defendant's vehicle?
I did.
And what was your ultimate determination about whether or not those 2 vehicles were in a crash?
So myself and my sergeant walked around the vehicle, Mr. Love's truck, walked around the defendant's vehicle, and the damage to Mr. Love's truck, the lack of damage of Mr. Love's truck, and the extensive damage to the rear of the defendant's vehicle, it was very inconsistent.
And you said the lack of damage. Was there any damage to Mr.
I didn't
Love's
see
vehicle?
any damage on the tractor trailer.
And based on your experience over 200 traffic or crash investigations, would you have expected to see some sort of damage to Mr. Love's trailer that was consistent with the type of damage of the defendant's vehicle?
That's correct.
And the conclusion of your investigation was?
No crash had occurred
between those 2 vehicles?
That's correct.
Now, after concluding that there was not a crash between those 2 vehicles, what did you do next?
Due to the indicators that I had from the defendant, I initiated a DUI investigation.
And as part of that DUI investigation, did you ask the defendant whether or not he had consumed alcohol recently?
I did.
And what was his response?
The defendant told me he had a beer at his friend's house.
Just one beer?
Yes, just one beer.
And you were still able to smell alcohol on his breath at what is now, do you remember what time the crash investigation took place?
I don't remember. It's probably between around 5 in the morning.
Okay.
5:30 in the morning.
And do you remember when the initial dispatch call that you received went out?
It was around 4:30, approximately 4:30 something in the morning.
Okay, and this is at mile marker 89.
That's correct.
So you stated Alligator Alley starts at mile marker 25.
That's correct.
So if someone was traveling from Broward County to mile marker 89, let's just hypothetically say for the speed limit, generally how long would that take them?
Approximately an hour, about an hour.
Okay, so even though the defendant stated he had only consumed one beer, you stated you were still able to smell an odor of alcohol what would have been hours after he had consumed that one beer?
Correct.
What else did your DUI investigation consist of?
It consists of field sobriety exercises.
And did you perform those field sobriety exercises on the side of I-75?
I did not.
Where did you perform those exercises?
Due to the shoulder being very narrow and for the safety of myself and the defendant, I asked the defendant if he would be willing to perform these exercises. And if he would, we'd be going to a parking lot located at mile marker 100, which is about approximately 11 miles from the scene, in which he agreed. So it's a safer location.
And mile marker 100, as you previously testified to, is the western boundary of Alligator Alley.
That's correct.
So the toll booth in Naples.
Yes.
Did the defendant agree to perform field sobriety exercises?
He did.
And was your car equipped with dash cam that day?
Yes.
Did it record your interaction with the defendant that morning?
Yes.
And Your Honor, I am showing counsel what has been pre-marked as State's Exhibit 3.
All right.
No objection.
Right.
I may approach, Your Honor.
You may.
Thank you. Yes, I'm showing you what has been pre-marked as State's Exhibit 3. Do you recognize what this is?
Yes.
And what is that?
It's a redacted CD, a video of the field sobriety exercises.
And how do you know that to be, or how do you know this CD to contain that?
It has my initials on it, and I watched the video.
And you've watched it. Is this a true and accurate representation, even though it's redacted?
Yes.
And Your Honor, the state would move to admit State's Exhibit 3 in evidence.
Any objection?
No.
All right, State's Exhibit 3 will be admitted.
And Your Honor, the state would request a published part of State's Exhibit 3.
All right, go ahead.
There is permission to relocate as we did yesterday.
You may. And where do you want the TV set up?
I think it's best if we move closer. The audio on this video is not as great as the other.
All right, I'll go ahead and relocate also.
What is the gas station? And where your location The GPS, Weston? Yeah. That's what I'm off of today. The highway, bro. Send me your location, okay? How the fuck am I gonna do that? Bro, they towed my car and everything, dude. Send me your location. Go to sideline. It's an app. It looks like a little circle here. I don't have that. Okay, follow to me. We're on TV. You're gonna send me a message. You're gonna send me a text. There's photos of me.
We're able to find out that you subscribation methods. And then I do from there. You go, okay.
I gotta go to my church my video, so we're
Hang on. For my safety or officer safety, I'd rather not show up on school while we're performing the exercises.
Alright, well, I can't tell you what I'm gonna do, but we're gonna do the exercises first. And then after that, then it's
Just for the record, I had some, had for my drug examination, late part of the project exercises. Just want to say right next to you. So, Trooper, you transported the defendant to the mile marker 101 toll area, conducting field sobriety exercises. What is the purpose of field sobriety exercises? And what was the first exercise you asked the defendant to perform?
It's called INDIRECT.
And
Actually, the defendant to stand his feet together, hands down to the side. I have a stimulus. How do you have a movie?
you don't have to show it off.
So I said what I do is I ask the defendant to follow those stimulus. I won't be on instead.
And Your Honor, if I may, thank you. For the record, your line session video at 6 minutes and 13 seconds. So, Trooper, the first exam that, or the first exercise that you had the defendant participating is the eye, as specified to. What were your observations of the defendant during the eye exercise?
In this exercise, I noticed, as I got closer to the exercise, I to get close to the defendant, a stronger odor of facial area. I also, during the exercise, I noticed the defendant following with his head slightly when I went to do the move slightly to the right. When I was doing the exercise, I followed his head. I also noticed the defendant swaying a little bit during the exercise. Was also indication of possibly being impaired.
So the observations that you just stated are observations based on your training. What was the second exercise you asked?
The second exercise is called a walk.
And can you describe that exercise to us?
Yes, actually, the defendant, initially, for this exercise, I asked the defendant if he would ever wear sandals. I asked him if he would ever wear sandals on the exercise. And the defendant said he didn't get sandals. Therefore, I instructed the defendant to, so the line that I used is a parking space divider to use in a line, but when I didn't do that, I used a parking space divider, which is a very big line, 4 to 5 inches. And I instructed the defendant to place his left foot on the line and place his right foot in front of his left foot. Keeping his arms down to his side and maintaining that position during the instructional phase. The defendant was then instructed to take 9 to 2 steps down the line, and on the 9th step, keeping his front foot on the line, by taking a series of small steps to turn back around. Then the defendant was also instructed to step.
And Your Honor, for the record, starting again at 6 minutes.
Stop. You did it at 11 minutes and 7 seconds. So Trooper, the walking turn was the second exercise that the defendant performed. What were your observations of the defendant in the walking turn exercise?
I had been instructed twice. The defendant instructed not being exercise will do so. He being exercise before I was instructed to. Also, on the way back, trying to step back, he did step, he was no longer did step, I believe. And he did an improper turn.
How's his balance?
His balance, back to
and why were those observations important to you based on your training experience?
These are significant indicators of impairment.
And what was the third exercise?
The third exercise was the one-legged stand.
And can you explain one-legged stand to us?
Yes, the one-legged stand is an exercise that the defendant is instructed to stand with his feet together, arms down at the side, raise either leg approximately 6 inches off the ground. While holding that position, the defendant is instructed to watch his foot and count out loud 1,001, 1,002, 1,003, and so forth. The full stop.
Thank you. Hey. For the record, restarting video at 11 minutes and 7 seconds. For the record, Your Honor, so it's out of the exhibit at 4 minutes and 20 seconds. So, Trooper, the third and final exercise you asked the defendant to participate was lying in stand. What were your observations of the defendant during lying in stand?
During the section that I was in our team grounds, the defendant was also shook his leg straight, and at one point during the also, the defendant counted 14 twice. 1001 was up. 14 twice, and used his arms in that.
Did he place his foot down at any point?
He did.
How many times do you recall? From what we just watched?
I don't recall.
What did you do based on your observations that you had already made at mile marker 89? Based on your observations of the field variety exercises, what did you do next?
It was based on the DUI.
Thank you. And Trooper, can the Trooper return to the stand now?
Yes.
Thank you. And I am.
Very good, thank you.
May I resume, Your Honor?
You may.
Thank you. Trooper, you said you placed the defendant under arrest. What did you do after you placed him under arrest?
Transported the defendant to the Collier County Jail.
And on the way of your transport to the Collier County Jail, how did the defendant react?
The defendant was, he had drastic mood swings during the transport. He, from being insulting to angry, crying, and threatening during the transport.
What were some of the comments that he made to you?
That he would, that I would always remember this case, and that he would have me in court during this. He would make sure he would bring me to court in reference to this case. That it was my fault that he's in that situation as well, and the rest were just insulting.
Can you tell us some of the insults that he called you?
I don't recall.
Yes. Sustained. Next question, Counselor.
Trooper, while at the Naples Jail Center, did you request the defendant to provide you a breath sample?
I did.
And what was his response?
His response was, I don't give a F, get away from me at first. And then I asked again a second time, in which he refused.
Did you advise the defendant of his rights to give a breath sample, or for that matter, the penalties of not providing a breath sample?
I did.
And can you tell us what some of those penalties are for not providing a breath sample?
I read implied consent to the defendant, and these penalties are if you have refused prior within 12, if you have a prior refusal, your license is suspended for 12 months, and it's a $500 civil penalty as well, and if for your second refusal, it's a second-degree misdemeanor, I believe.
And as part of implied consent, was the defendant advised that his refusal could be used against him here today?
Yes.
After reading the defendant implied consent, did you ask him to provide a breath sample again?
I did.
And what was his response after knowing the consequences of not providing that breath sample?
He indicated to me a refusal.
Thank you. No further questions, Your Honor.
All right. Defense, any cross-examination?
Yes, Your Honor.
Yes. You may.
Good morning, Trooper.
Good morning.
May it please the court, counsel, thank you. Trooper, you were working, you stated on direct, you are a trooper with FHP, and you're still employed as a trooper with FHP?
Correct.
And you were so employed on April 25th of 2020?
Correct.
And you, around 4 a.m. were on Alligator Alley?
Correct.
And that's approximately the time that you were dispatched to an incident at mile marker 69, correct?
Correct.
And when you arrived there, at first you met solely with Mr. Love, correct?
Correct.
And you didn't get to the scene with Mr. Love until sometime after that dispatch, given the distance of where you're located, correct?
Correct.
And fair to say it was probably about 4:36 approximately when you arrived on scene?
Approximately.
And at that time you got Mr. Love's version of events?
Correct.
And you've testified to what that was on direct today, correct?
Correct.
And you also testified that after getting his version of events, he followed you and you drove to mile marker 89 to meet up with Trooper Munoz.
Sergeant Munoz.
Sergeant Munoz, I'm sorry. Fair to say that a fair amount of time passed between that initial dispatch shortly before 4 a.m. and when you met up with Sergeant Munoz?
Correct.
And when you came into contact with Mr. Smith, it was also much, pardon me, much later than that initial dispatch call.
Correct.
Essentially, you met up with Mr. Smith at the same time you encountered Sergeant Munoz.
Yes.
And Mr. Smith had told you that he was hit by a semi, correct?
Yes.
And you testified on direct that you noticed significant damage to the back of his car.
Yes.
Did you notice the fresh glass in the back seat?
Yes.
And
I'm not sure if it was fresh, but there was glass in the back seat.
Evident of a recent incident.
Correct.
And officer, you don't wear a body worn camera?
We do not. I do have a mic and in-car camera.
And would you agree that body worn cameras are...
Objection, Your Honor.
Can you finish your question?
Body-worn cameras are used by other agencies to document citizen encounters and investigations.
Objection, Your Honor, to relevance.
Sustained.
You had a dash camera for this incident?
I did.
And you just testified previously that you had a mic. Is that mic linked up to your dash cam?
Yes.
Okay. And that's the footage that we just watched, correct?
Correct.
In a redacted format, but
Correct.
that's the link up. Okay. And you testified on direct that you determined that the semi did not have any damage when you inspected it, correct?
Correct.
And did you inspect the semi's tires?
My sergeant and myself, I personally did not inspect the tires, but my sergeant that was arrived on scene as well. Yeah, he's a CVE trooper, 15 plus years.
And I don't mean to cut you off, but my question is, did you inspect Mr. Love's tires?
We did. We did a walk-around inspection of the vehicle.
But you just told me that you yourself did not.
I didn't measure the tire and stuff like that.
Okay. Did you see, strike that. You did see the Amazon semi when you met up with Mr. Love?
Yes.
And you would agree that it's much bigger than Mr. Smith's Nissan?
Correct.
And you stated that you've been on the job for how many years?
3.5.
3.5, and roughly 200 car accidents and some 15 to 20 DUIs, correct?
Correct.
And in those 3.5 years of experience and 200 crashes, you would say that sometimes not all cars have equal damage.
That's correct.
Especially smaller cars when they get into a fight with a bigger car.
Correct.
And in cases where a much larger and heavier car is involved with a much smaller, lighter car, reasonable that the smaller car would have more damage.
That's correct.
And isn't it true that you have investigated accidents where one party may not even realize that they were in an accident, given the fact that they're in a much larger, safer car?
Correct.
And Mr. Smith told you that he was trying to get the truck driver's attention that night, correct?
I don't recall.
Objection, Your Honor. Hearsay.
Overruled.
You don't recall?
I don't recall.
Okay. And officer, trooper, I apologize, when you were on scene and conducting a crash investigation, how long, is it fair to say that that crash investigation only lasted a couple minutes before it turned into a DUI investigation?
No, we were actually on scene for quite some time.
But how long before that crash investigation turned into a DUI investigation?
Approximately 40 minutes.
And you testified on direct that Mr. Smith did agree to do your exercises with you?
Yes.
And he did agree to do them, and he had told you that he felt he was hurt from the accident?
He did agree to do them, yes. And I don't recall if he said he was hurt. During the exercise, I believe he said that he was involved in a crash or something like that.
And he had told you that he was involved in a crash much before beginning FSCs, correct?
Correct.
And oftentimes when people are involved in crashes, they don't feel injuries right away. Wouldn't you agree?
I could agree. Yeah.
And oftentimes, especially being that you've investigated over 200 crashes, a lot of times people who are involved in these accidents, they feel a sense of adrenaline, don't they?
Correct.
And so it's possible that at the time you initially encountered Mr. Smith, he was experiencing that initial adrenaline.
Speculation, Your Honor.
Is that an objection?
Yes, Your Honor.
Sustained.
Officer, you've done these field sobriety exercises many times, correct?
Correct.
April 25th, 2020 certainly wasn't your first time doing them, was it?
No.
You've practiced them with work and you've done them on the 15 or 20 DUI investigations you've done?
Correct.
Would you agree with the statement that practice makes perfect?
Correct.
And to the best of your knowledge, this was Mr. Smith's first time doing the exercises?
I'm not sure.
Would you agree that doing field sobriety exercises after a traumatic accident would make them more difficult?
That's always something that we take into account.
I'm sorry, I couldn't hear you.
Again, objection, speculation.
Your Honor, if he's trained in 200 accidents and 15 to 20 DUIs, I don't believe it's speculation. That would come with his training and experience.
You may. All right, sustained as to form.
Trooper, you testified a second ago with me that anyone involved in an accident could make doing your exercises more difficult, correct?
That's always something that we take into account.
And fair to say that you didn't take that into account with Mr. Smith,
I did.
yet you still had him do the exercises.
Correct.
And when he mentioned he needed EMS, you denied that request.
He asked me if he needed. It was a question. He didn't say I need EMS.
Nonetheless, though, having just been in an accident that you saw and had your testimony being that people may not perform to the best of their ability, did you consider that when it came to Mr. Smith performing your exercises?
If he needed EMS?
No, if the fact that he was just in a car accident was going to affect his performance on your exercises.
Correct.
You did consider that.
I was aware, but since I didn't notice a crash had happened, my crash investigation revealed the crash hasn't occurred. I didn't
But you just testified that his car.
Go ahead.
No, that wasn't responsive to my question, so I'm not going to engage further. I'm going to move on. When it comes to the pen to the eye test, you stated on direct that protocol calls that you use a stimulus. Sometimes is that the end tip of a pen, or what would you normally use?
I would use, it depends. Usually I use my stimulus or a pen, whichever I have handy at the time.
And when you say stimulus, what is that?
That is a pen. It's very like a pen, but there's a light at the tip.
And we see in the video a red light somewhat going across my client's face. Did you use that tip with the red light on that day?
Correct.
So if protocols for the use of a pen cap, and your understanding is that Mr. Smith was just in an accident, you still elected to shine a red light in his face?
The light doesn't shine directly in his face, it shines up.
But you testified on direct that you're very close
I am very close.
with
and there's just a light. It doesn't shine in his
But that's not my
direction.
question, not trooper. But so you were very close,
Correct.
and you elected to use the stimulus with a red light
Correct.
to near his eyes.
To mirror his eyes. I don't know.
No, near his eyes.
Oh, near his eyes. Correct.
And you did testify earlier, not only on direct, but also in questions with me, that in your training and experience and in your crash investigations, that oftentimes people are unsteady, unbalanced. Did any of that weigh into your decision-making when being up close and personal with Mr. Smith and shining a red light near his face?
Ask the question again.
When you're of the agreement that accidents cause people to be unsteady and unbalanced. When you were asking him to remain steady and balanced with a red light stimulus near his face, did it occur to you that he may not be as steady on his feet as someone who was not in an accident?
I'm not understanding the question.
Okay, I'll move on. You stated on direct that during the pen test, Mr. Smith was swaying?
Yes.
And is that common for someone who's just been in a car accident to be unsteady on their feet?
It depends.
Okay, and did you also notice that the trees behind him were swaying?
I did not notice the trees in the back.
And they're rooted in the ground, wouldn't you agree?
I don't recall seeing trees in the back.
Okay, and then the next exercise was the walk and turn. Now in the walk and turn, we watched the instructional phase, which you had testified was a little bit more lengthy. During that exercise, before he began, Mr. Smith said, "Oh, I have my cell phone," and you said you can go put it on the hood of my car, correct?
Yes.
And he walked to your car,
Yes.
placed his cell phone down,
On the hood. Correct.
turned around and walked back?
Correct.
Okay. And he didn't fall down when he did that?
No, he did not.
And you would agree that walking and putting something down and turning back is much more normal than a choreographed exercise in a parking lot, correct?
Could say so.
Now, for the actual exercise, when you were explaining it, we see on the video that Mr. Smith walked the first 4 steps with you to practice, so to say. Did you notice he was doing that, or was seeing it on the first video? Because it was a little bit behind you.
As I was reading instructions?
Correct.
Yes, I noticed.
And he walked straight line, didn't fall?
I wasn't paying attention to how he was walking because I was reading the instructions off my agency issued card.
Okay. Now, after you were done reading instructions and it was time to start the exercise, Mr. Smith again told you that he was hit and stated that he thought he needed a paramedic, correct?
He asked me if he needed a paramedic.
Do you recall just watching the video?
Yes.
And it's your testimony that he asked you if he needed a paramedic?
Yes.
Okay. When you began the exercise, official start time, he did walk the entire 9 steps forward, correct?
Correct.
And he did walk the entire 9 steps back?
Correct.
And he kept his balance during the instructional phase, during the walking phase. He didn't fall down?
He didn't fall down.
He didn't need to hang on to you for support?
He didn't hang on to me for
He
support.
didn't need to hang on to a car for support, as oftentimes you see?
No, he didn't need to hang on to me.
My apologies. And as we see in the video, Mr. Smith never once walked off that line.
He didn't walk off the line.
And he walked the correct number of steps without falling.
Correct.
You stated in your report that he was able to essentially perform the exercise, correct?
He did perform the exercise.
And you would agree that walking heel to toe 9 steps, I'm doing it in heels, but walking heel to toe in a small series of steps like
I'm not sure. It's, that's the rules and that's what I'm trained to.
I understand you're following procedure, but in your daily life, it's not a very common task that you do. Would you agree?
I don't take serious steps like that every day, no.
And if you're not feeling well and you're wondering self, is there something wrong? Do you have yourself do heel to toe, or are there other ways you check if you're in any way not right?
Objection, Your Honor, relevance.
Sustained.
You filled out a report based on your observations of Mr. Smith?
Correct.
Sorry, let me backtrack. The next exercise you did was the one leg stand, correct?
That's correct.
And Mr. Smith was able to pick up his foot to the best he could?
He lifted his foot from the ground, correct.
And he didn't fall down?
No.
He didn't have to hop to keep the leg up?
No.
And he was able to perform this exercise to the best of his ability, being in sandals?
Correct.
And you would agree a one leg stand is not a very common task for civilians?
And Your Honor, relevance.
Overruled.
It depends.
Would you agree that most civilians don't stand on one leg in a toll plaza parking lot?
I could agree.
And during the one leg stand, had Mr. Smith told you, strike that. Mr. Smith did the one leg stand after he did the heel to toe, correct?
Yes.
And it was during the heel to toe that he had mentioned EMS and paramedics, correct?
When he asked me if he needed, correct.
So he did this exercise again after asking for medical attention.
Correct.
And you filled out a report of your observations. I believe it's called the DUI packet.
Yes.
And in that packet, you put down that the condition of his clothing was.
Objection, Your Honor. Hearsay. And improper impeachment.
Not impeaching him.
Sustained.
Officer, do you recall stating that Mr. Smith was disorderly?
Objection, Your Honor.
He's already testified that he was disorderly. Overruled.
Do you recall stating that Mr. Smith was disorderly?
Yes.
And do you recall giving a report in this matter?
I didn't put it in my report that he was disorderly, no.
Okay. And you testified on direct that his speech was somewhat hard to understand and slurred?
Correct.
And that at one point he became incoherent?
I don't recall.
Did you had stated that, you don't recall. Officer, you read Mr. Smith implied consent at 7:24 a.m. approximately?
Approximately, yes.
And you would agree that that's what time the implied consent affidavit was signed?
Correct.
And we've already, I know, gone over this. 7:24 is approximately 3.5 hours after the initial call, correct?
Yes.
And you stated on direct that based on your observations at mile marker 89 and my client's performance on the exercises, that he was placed under arrest, correct?
Correct.
Whether or not he blew into the machine with you, were you going to unarrest him?
No.
So regardless, he was remaining in custody?
Correct.
I have no further questions.
Your Honor, may we approach?
Yes. Members of the jury, at this time, we've been going for a little over an hour. We're going to take a brief recess to give you all a comfort break, and then we'll have you come back in and we'll continue. All right?
All right, for the jury.
Thank you. You may be seated. All right, thank you. All right, we'll be on a 5-minute recess.